Please the court. My name is Tim Boston. Along with my colleague Ari Jones, we represent the appellant, Hannah P. The question before this court today is whether the appellant has a right to lost wages related to the cyber position. On this issue, the trial court made the pertinent finding below that, quote, on this record, it would be too speculative to conclude that OD&I would have selected Hannah for the cyber position if she had been allowed to take leave on April 9th. This means whoever had the burden below failed to prove the matter, and they should have lost the case. The court's recent decision in the Roberts v. Geestamp, West Virginia LLC case makes clear that the ultimate burden should have been on the employer in a case like this when you're considering the loss of a job. Therefore, when the trial court placed the burden solely on Hannah, the plaintiff below, the lower court erred as a matter of law, and this court should reverse the decision. For an FMLA interference claim, an employee must prove three things. One, that they are entitled to an FMLA benefit. Two, that the employer interfered with the provision of that benefit. And three, that the interference caused harm. Hannah easily prevailed on the first two elements. And on the third element, she showed, and I'm quoting testimony from Mr. Ewing below, in making the cyber hiring decision, OD&I considered the attendance issues Hannah had in April of 2015. This is Joint Appendix, page 86. It was these April attendance problems, during what we have called in our brief the interference period, that were directly caused by OD&I. And the reason why this was an interference that caused harm is because OD&I then considered the interference period attendance issues against Hannah in the hiring decision. And at that point, the burden should have shifted to OD&I to show, as this court said in the Roberts case, that to avoid liability, they must show it would have taken the contested adverse employment action regardless of the employee's FMLA protected leave.
Counsel, if I could interrupt you, I mean, certainly there are a lot of cases, Roberts and others, where we employ a burden-shifting type analysis on liability. And my memory of that's what Roberts was really about, is whether there was FMLA liability. Here, the court found liability as a matter of law, and we're talking about damages. So what's the basis for saying a plaintiff, once she has established liability, as occurred here, doesn't have the burden of proving her damages?
Your Honor, I think that was one of the many errors made by the trial court to say that the issue is one of damages. It's not an issue of damages. The third element that I just read from the Adams v. Anne Arundel case is a liability question. The plaintiff has the burden to show the interference caused the harm. So you don't, meaning the proximate cause that we would have had to show that the harm, the proximate cause of the harm led to the damage. The court made clear below that this was a proximate cause question. And I think there is some dispute over whether proximate cause is a liability issue or a damages issue when you look at case law. But I think the consensus is that proximate cause spans both liability and damages. And what the court was really doing was reversing herself, because the trial judge said at the end of the trial that we had won on liability. Then she came back in the final opinion and said, no, well, you didn't prove the damage, but it wasn't a damage question, Your Honor. It was a proximate cause question, which is properly, on an FMLA interference case, is properly looked at as a liability issue.
Going to the damages, does appellant seek consequential or direct damages?
Neither, Your Honor. I think that's a complicated question. Well, let me back up.
What damage does plaintiff seek, appellant seek?
Yeah, I mean, the specific answer is we're seeking the lost wages related to the cyber position. And yes, they are a consequential harm. And in that sense, consequential damages. I just want to be careful, though, because the trial court misused that term in this context, in the FMLA interference context, saying that you can't seek consequential damages under FMLA interference. But that's not accurate. What those cases had said, that it looked at consequential damages, they were talking about non-monetary issues, not lost wages, stuff like emotional distress. So here, we're seeking solely lost wages, only lost wages, related to the cyber position, and they are consequential harm.
So you agree, well, do you agree that consequential damages are not available under the Act, first of all?
I do not, and the Supreme Court decided that in the Ragsdale case and said that the damages must be consequential in the sense that they must be connected to the the harm that was created.
It's kind of interesting the way, that's been used. I mean, if you think in the traditional breach of contract sort of case, that's where that term comes up. It seems like that phrase is being used a little bit differently than the normal breach of contract case by both the Supreme Court, and I'm certainly not, saying that's wrong, but anyway, it just seems like we're talking about consequential damages in the way we would not have learned in, contract class in first year law school.
I agree, Your Honor, and I believe that's what threw off the trial judge. I mean, she really became the first trial court to dig into the issue of these are consequential damages. She then applied a test looking at intervening, superseding causes, really complicating the issue.
Isn't our Klein and our Dotson case, if you look at those, doesn't it refer to damages like you're seeking here as front pay? And it declares or has held that those are equitable damages. And that wasn't really addressed. I mean, you didn't seek them in that fashion, I don't think. But that got it raised in the motion to reconsideration, and the court addressed those there. Why wouldn't our Dotson and Klein cases, which talk about front pay as equitable remedies, be a way we look at this?
Right, Your Honor. I wish I could cite the case, but as I was preparing for this hearing, I actually came across a case, a Fourth Circuit case, that defined this. And what it said was back pay is all damages sought up until the day of trial. And then everything from there is front pay. And it's true, and this is just general law for FMLA interference, that normally, this was a U.S. government case, so we didn't have the luxury of a jury at all. But normally, the way this works is you go to a jury with your back pay, which is all lost wages, up until the court date. And then the front pay, which is an equitable claim, and it's up to the discretion of the judge, is all damages sought going forward. So we're talking about back pay because this case took so long to get to trial that I think we only sought back pay below. Actually, that's not true, Your Honor. We sought mostly back pay and a few years of front pay. So to the court's position.
Is your position this isn't front pay?
It is not.
If we disagreed, you, I think, as you said, that's an equitable matter to the discretion of the judge. Okay.
The law is clear. If it is front pay, it's equitable.
Right.
And obviously I lose because the trial court said she wasn't going to give equitable relief. But this is not equitable. It's money damages. It's back pay from the day of trial, March of 2021, I believe.
If this is a damages question, kind of back to the first point I raised, and you kind of said, well, it's proximate cause versus damages, those overlap. I understand that argument. But to the extent we're talking about damages, it seems like the standard for damages, whether we're in the ADA or Title VII, retaliation, where you use damages like because of, the courts have consistently, including ours, says that's just a but-for causation standard. And the district court may not have used that sort of analogy and phrases, but that's basically where the court came down and did the analysis. And I'm just trying to see why that's wrong. I mean, I certainly understand you got arguments that, the failure to take leave, was did cause, but the district court talked about other evidence that is pretty similar to what we did in our first decision here, and says, look, there's just evidence on the other side. Why aren't we just in that sort of situation, a but-for cause like we are in all these other federal statutes?
Right. Your Honor, that's a complicated question in some ways. I would agree with the court that the trial court did apply a but-for cause analysis to this case and put the burden solely on my client. I don't think there's any dispute that's what the trial court did. But it's wrong because we're in a category of FMLA, what are called not just interference cases, but entitlement cases. And the courts, the Throneberry Court out of the 8th Circuit, have looked at this and they said, is FMLA interference actually a strict liability case? Because the way the courts read, and even Roberts had language to this effect in its decision, this court's decision in Roberts, it's basically if you violate the FMLA, the plaintiff is entitled to their damages. We're in a really narrow subset of cases now that are these termination or lost job cases like Hannah has here. Very narrow set where it's not just the plaintiff has to show you violated my FMLA, I win, I get damages. But the court has said, well, wait a minute, sometimes the termination can be legitimate. So we're going to put the burden on these narrow subset of cases back on the employer. It's really a benefit to the employer, right? Because otherwise it's almost the strict liability consideration. Not quite, but almost. And now it's saying, look, we're going to help the employer by giving them one more chance to show they would have made the same decision regardless of the fact that they considered this FMLA interference. It's a unique set of cases. I mean, the most clear analog, though, Your Honor, would be the Title VII discrimination cases.
That has language in that part of the statute that says it's, I forget, you know the language better than me, but it has different language. All the cases that have the language like we have say it's but-for causation. And only in the status cases under Title VII where I think it's what's the word?
Same decision or the
motivating factor.
Motivating
it's
factor,
got actual language shifting it. Otherwise, we got all these cases say we just talk about but-for causation.
Right. The reason I believe, and I looked into this issue myself, let me just say it this way. All courts, including this circuit, have found that there is this burden shifting in FMLA interference cases, on these narrow subset of cases, just like the Roberts case.
But I just got to keep stopping you. I want you to answer, but that's in establishing liability, not in proving damages.
Well, Your Honor, I would say to the court, I mean, it was like the trial court said to us, you win, you showed that the interference led to the loss of the cyber job. That's what the court said, but you get 0 damages. I mean, that's under the court's reasoning. That's what the lower court would have said. But that makes no sense, right? What kind of Pyrrhic victory is that if they're like, well, you won, but you get nothing? Because we can't apply the same decision test on damages, but we could have applied it on liability.
That happens all the time in the law. You win on liability, someone violated a duty, but you can't show damages other than amounts that aren't as much as you'd like.
But the issue here is, and the ultimate question really is, what does the plaintiff have to show to prevail? And what we're saying is, you just have to show they considered your FMLA interference, and then they have to show that they would have made the same decision. And it should have happened at the liability level, right? That's where the trial court should have made that decision. Instead, the trial court basically said, well, you win on the cyber, now write your briefs on mitigation of issues or damages. And it jumped over the same decision test. But it should have been at the liability level, Your Honor. I mean, all the cases that have addressed this, all the circuits have said it happens at the liability level. And if you prevail at the liability level, then you've won. You've shown proximate cause by establishing the prima facie case, and then the employer's got to prove they would have made the same decision. So I think, the FMLA interference, the entitlement statutes make it very clear that these damages are almost to be presumed. And it's the employer's burden to show they would have made the same decision. And it's not fair to Hannah to say, well, they got screwed up at trial because the trial judge said you won on liability, only to come back, on a post-trial brief and say, well, yeah, but I'm going to give you no damages for the same analysis that should have happened at the liability level on proximate cause. I see I'm running low on time, and Judge Quattlebaum mentioned also the issue of the mandate. I obviously think we have the same panel here, so I would defer to the panel's opinion or thoughts on their opinion the first time. But I would say, as far as the law of the case doctrine goes, you don't reach things you don't talk about in one opinion. And the first opinion, there was nothing about these damages being inappropriate under FMLA interference. And so I do not think the court reached it in the first opinion. It should be reached this time in this court's opinion. And I believe I'm out of time. Thank you.
Thank you, Mr. Boston. Ms. Lopez?
May it please the court, Carolyn Lopez on behalf of the government. I wanted to start off by discussing the question that seems the most teed up, which was how does the burden shifting work at the damages stage as opposed to the liability stage? And so the Roberts case that was raised in the reply brief, that's quite clearly a liability stage case. And under the Supreme Court's governing precedent in Babb versus Wilkie, the Supreme Court has made quite clear that regardless of what happens at the liability stage in these types of statutes, so that was an ADA case, in these types of statutes, it's always the plaintiff's burden to show but-for causation for the adverse employment decision. And so under Babb versus Wilkie, that answers the damages question that sort of is left open by Roberts as to what then happens at the damages stage. And that's also consistent with the Supreme Court's governing case in Gross versus FBL. And so that's at page 180 of Gross. And sorry, the pin site for the prior case is 1177 through 78. At page 180 of first at page 176 of the Gross case, the Supreme Court says the ADEA language in that case was because of, and so at page 176, the Supreme Court says the because of language is like by reason of, which is the language that's used in the FMLA damages provision, which is different and distinct from the language in the FMLA liability provision, and that's why there's a difference in terms of how the burden works. And then at page 180 of Gross, the Supreme Court said that it's always the plaintiff's burden to show that the consideration of the prohibited factor was a but-for cause of the decision, and the Supreme Court specifically rejected the contention in that case that if the prohibited factor had been sort of a motivating factor and there was some evidence of that, that would be sufficient. And so under that governing law, what the district court did here was absolutely correct in terms of how she placed the burden.
Aside from the burden, what's your position on the damages that appellant seeks and whether they're available under this statute?
I want to make sure that I am understanding your Honor's question. We think.
Go ahead.
We think that in this particular case, in light of the factual findings that the district court made, that this court doesn't need to address whether, in this particular context, those would be sort of classified as consequential damages or direct damages, because it sort of doesn't matter in light of the dispositive factual finding that the district court made here correctly under the Babb v. Wilkie and Gross standards.
Ms. Lopez, what factual finding did the district court make that makes you say that they didn't reach the but-for causation? Let's assume you're right, that it is but-for. What fact that was found by the district court that would make you conclude that it was not met here?
Oh, sorry. Thank you, Your Honor, for the opportunity to clarify. The district court applied the but-for. We agree that the district court applied the but-for causation standard and
what
did so
facts in this case suggest that that was correct?
That
That the decision
that the decision was not clearly erroneous based on the facts in the record, Your Honor? Absolutely, Your Honor. I think that that was particularly on a clear error standard where the question is not whether or not the court sitting de novo would agree with the district court. The district court cited ample evidence that aligned with this court's decision, for example, at page 3.
What's the ample? I'm just giving you an opportunity before I weigh into you as to, in fact, what facts do you suggest that make it clearly that it's not erroneous?
Yes, Your Honor. So again, keeping in mind that the standard is that it is plaintiff's burden to show.
No, you know what? No one wants to talk about the facts of this case because the facts make this case, to me, very simple. That's why I want to tell me the facts that support the decision that she wasn't entitled to damage.
Absolutely, Your Honor.
Yeah.
So the facts are, as this court recognized at page 334 of its prior opinion, and the
The
district
prior
court
opinion didn't deal with interference, okay? Let's talk about the interference.
Yes, Your Honor, but it does have to do with whether or not the district court's decision that the decision makers' consideration and knowledge of the pre-leave conduct, so her conduct that required a referral, an EAP management referral to EAP was significantly serious enough that that altered his impression of her, and he, quote, and this is at JA 318, simply was not interested in hiring her thereafter. And
But
that,
counsel, that's the problem of this case. She should never have been referred to EAP. Matter of fact, it was mandatory. It was mandatory. They knew all along. I mean, this case to me turns logic and justice on its head. She was assigned one of the most important cases in America at the time. She was chosen to lead the investigation about Snowden, answering the White House questions, Congress questions. She led multi-agency investigations into that and did that, and dealing with depression issues back since 2011. And she worked through it for 18 months and did that. And then at the end of that, these things came upon her. They knew about her depression. They knew major, severe depression. And she came to her psychiatrist, and her counselor said, you need to step down. Your brain needs rest. 4 to 6 weeks. Didn't even tell her she was entitled to FMLA benefits. The woman who had done all this for her nation, and then said, you go to EAP, mandatory. That's like somebody coming with a broken leg, and they say, my doctor said I need to be off my knee. Oh, go to EAP first and see what's wrong with it. We know what's wrong with it. And there's nothing in this record to contradict the evidence about her mental health issues, nothing. And then you go to EAP, and then the counselor talks about, well, what's your real problem? Oh, she's really not satisfied, not satisfied because she hasn't gotten a permanent position yet. No medical evidence to support that at all. And then so we're gonna put you on a plan where we're gonna call you. People who are depressed don't show up. They're not late because they don't have a clock at home, an alarm clock. You tell me what facts suggest that you can do that to someone, violating the spirit of Congress, not this court. We don't make the law. The law was made to protect people. This case is one of the most egregious cases I've ever seen in terms of MLA violations. Now, again, I'll ask you again, what are the facts that support that this was not a clearly erroneous decision on behalf of the district court? You give me the facts.
Your Honor, if I might, with the court's indulgence, if I might have the
I'm going to
opportunity
indulge you
follow
only
up.
to the extent that it'll give you time to answer my question.
Absolutely, Your Honor. So again, that EAP, and this court, the question of whether or not this was because of her depression was, of course,
It's
squarely
undisputed.
decided in the prior
Counsel,
case.
it's undisputed. Is that correct? Is it undisputed that she had these significant medical health issues? Yes or no?
Your Honor, I'm not, that, we haven't disputed that she has depression, but the question is whether or not she can bear her burden to prove that she lost her cyber position because of that under an FMLA interference claim. And here, if I might just talk about
You don't need to dictate the law. The
if-
facts are here. As a wise professor of mine in law school said, it's the facts that always determine what you need to do. You're trying to avoid those.
Absolutely not, Your
You
Honor.
are,
So if I
because
might
what for
talk
him, the
about
facts was this. When they sent her to EAP, then that counselor went and told her, it's really not the problem of medical condition. It's that she's having these issues about sour grapes and not motivated that. And that poisoned the tree. That poisoned the tree. And the little plan they came up with, they gave her 2 days. Oh, you're late. You didn't get here about 11. That's not going to work. And she was spiraling down. And it did influence. The record is clear to influence her. Attendance was the only thing, because she was getting brilliant, excellent, doing when she was working on Snowden and all of those things. So that's not a question. The question was, they sent her to AEP, and that became sort of like the subterfuge. She should have never been there. You tell me why you send a person to EAP, mandatory, when there's undisputed evidence that they need to be off 4 to 6 weeks for a serious medical condition. You tell me what law in this country says FMLA should be applied by in such an egregious way these facts.
Your Honor, we're not disputing any liability findings that were based on FMLA.
You are. You're disputing because you don't
We
want
are.
to give her the consequences and the direct results of what you did. She lost a job because when she went to EAP, they came up with another reason other than medical is why she's late. That is directly related to why she didn't get the job. She probably should have got the job anyway from a permanent position. I think I would have been frustrated too if I worked on one of the major cases like that for our nation and then you can't get a permanent job. Is that?
No, Your Honor, I respectfully disagree.
Respectfully disagree with what? You haven't stated a fact yet.
If I might actually talk about the EAP
I'm giving you a chance to answer my
memorandum,
question.
then, so that's
you,
at JA.
Counsel, don't talk over me. You had a chance. I've asked you the question over and over again. What facts?
Yes, Your Honor. So the facts are that
the
her
EAP
intended,
facts.
the
Go ahead.
EAP facts, which were written before her very first leave request when she disclosed the depression, the facts of that EAP memorandum are she had increasingly erratic attendance, and this again is in the national security context. And the part, it's not just that she sort of wasn't there during core hours so that her assignments had to be handed out to other folks. It's that in the national security context, if you don't show up at work, it's not sort of as if somebody's teleworking and you kind of don't know whether they're on their computer or not. It's imperative to notify your supervisors of your whereabouts so they know you're safe. And this is all documented in the EAP referral memorandum, which the district court, which both this court previously and the district court cite. It's documented as the decision makers' knowledge that these issues were occurring as early as the January, February, March timeframe. It's discussed at JA 306 of the district court's opinion. And so, again, Your Honor, I absolutely understand how a different fact finder might have come to a different conclusion, but that doesn't make the district court's
But they're
careful
all
analysis
related to
here.
her illness.
But the question...
I don't understand that. She was sick. And you knew that her direct supervisor, the second line supervisor, knew that she was having, matter of fact, he went there, he said, I think she's having depression issues. He said that along, but this was in the February time frame. And now you just knew it like, oh, well, we had to do this. We had to know where she was. You knew where she was. She was someone who needed 4 to 6 weeks. And when she had the 4 to 6 weeks, if she came back, all that it began to improve. But again, the die was cast because what came from the EAP. I don't. Go ahead. You go ahead. I mean, it's unbelievable.
Is there language in our prior opinion that you rely on for the argument you're making here?
Yes, Your Honor. So there's also language in the prior opinion. So that's at page 334 of the prior opinion. And just sort of to cite to certain snippets of it. So by March 2015, now the leave request is April 9th, so after March 2015, of course. By March 2015, plaintiff's coworkers perceived her schedule to be erratic. She had racked up numerous unplanned absences, and she was unreachable for hours, often missing work and failing to return repeated phone calls. And so it was in that context that the agency thought it was a serious enough issue that there was a referral to EAP. And that exact time frame is why the district court held here that that the decision makers, which I think I cited at JA 306, she discussed how it wasn't just his knowledge of the EAP referral memorandum. He'd been sort of brought in informally to be apprised that this situation was happening before then, and that his mind was made up, and he was simply not interested in hiring her thereafter. And clarify that further on the reconsideration decision in saying that at core, and that's she was sort of reviewing her own prior finding under also a clearly erroneous standard. At core, a plaintiff simply disagrees with the court's finding that Ewing's mind was made up not to hire a plaintiff for the cyber position independent of the FMLA interference.
So counsel, if I could follow up, it isn't the finding of liability was that, when she came, I think in April, early April,
Yes,
they
sir.
should have notified her of her FLMA rights.
Exactly, Your Honor.
And the district court found that they did not, and that violated the FLMA.
Absolutely, Your
And
Honor.
as I understand the claim related to the cybersecurity job, it's that because they didn't do that in April, she had continuing attendance issues in April and thereafter that cost her that job.
Yes, Your Honor.
The district court, as I recall, just similarly to the way we addressed the retaliation claim, and I think that's not necessarily law of the case, that's a separate issue, but there's some, at least context from that, that there were facts that predated the obligation to notify the plaintiff of the FLMA rights. And that's what it looked like the district court caused the district court to say, to me, to the court, it's too speculative to tie all this to the post FMLA obligations.
Yes, Your Honor.
Is that, and the district court cites those on page 22 of the order, original order,
Yes.
that are similar to what we cited in our initial opinion.
That's exactly right, Your Honor. And I apologize, I'm going off of JA sites at this
Yeah,
point, so
yeah,
I'm not sure
I
that they
should give you
quite,
those. That's fair enough.
quite line up. But yes, Your Honor, Judge Brinkema did walk through those
And
same
it could
factors.
be, the case could have been prosecuted or pursued, and I can't recall, maybe it was, that the FLMA obligations began earlier. And if there had been a finding that the FMLA obligations began, say, in January, we might have a different case here. But what we have here is a case that the FLMA obligations began in April, and the claim is what happened in response to that.
Absolutely, Your Honor. And the district court walks through why she rejected plaintiff's theories about why that later behavior, why those later issues changed the outcome. And again, so the district court reasonably found on the record before her after a full bench trial.
I want to go back to the burden of proof. If we conclude that the district court imposed an incorrect burden of proof, do you still have an argument as to how you would prevail or your client would prevail?
We think that the district court's clarification on a motion for reconsideration, that the plaintiff simply disagrees with the finding that the decision was made independent of the FMLA interference, is sufficient to prevail under any standard. But we do also think that under Babb versus Wilkie and Gross versus FBL, it's crystal clear that at the damages stage, and again, even in opposing the motion in limine at page 8 of that opposition, plaintiff made quite clear that they were relying on the cyber position not as part of the liability phase of the FMLA interference, but just at the damages phase. And at the damages phase, Babb versus Wilkie and Gross versus FBL make clear that the district court, in fact, applied the absolutely correct standard here.
But if we disagree, following up on Judge Thacker's question, how could we say that you prevail on damages if the burden was on you? The whole context of the district court's decision was that the plaintiff didn't meet their burden. I think that's an important question, but if we were to come to the conclusion that the burden is on the defendant, I don't see how we could say the current orders allow us to reach the conclusion that the burden had been met.
If Your Honors disagree that Babb and Gross control here and require that the plaintiff show but-for causation, including that the same decision would not have been made, then the government would not object to a remand to the district court to apply the standard. Putting aside whether or not assuming no further proceedings were had after such a decision, the government would not, if the wrong standard had been applied, the government wouldn't object to remand in that context. Again, holding in reserve any decision about any governmental internal decision about whether further review would be requested, a decision that stated the burden that way.
Isn't there evidence in the record that Ewan said that he considered her spiraling down and increasing problems with attendance in April? He said may have considered it differently had that been different or better. Is there not evidence in the record of that?
Your Honor, I want to just be very clear about which evidence we're talking about. So I believe Your Honor may be referring to JA 86, which is the question about the decision maker discussing the conduct through April. And as the government has explained, because the FMLA interference was found to happen on April 9th, it was entirely appropriate for him to consider conduct through April means April 9th as well. And it's not, I know that my friend on the other side reads that to mean through the very last day of April, but turning to JA 86, it's quite clear that, so for example, he says, referring again to that EAP memorandum, that's what I'm thinking about. The EAP memorandum is again based on actions taken before and sort of formally issued on April 9th, before the FMLA interference, and to the extent that there's sort of any doubt on clarity on what that means, my friend on the other side, after he had said all that, used that same through April language in a manner that makes quite clear that there was, through April could refer both to the pre-April 9th conduct or post-April 9th conduct. And so it certainly wasn't clearly erroneous for the district court to in that context, find that he was talking about that pre-April 9th.
When the discussions occurred before that, when her supervisors clearly knew that she was having problems with depression, right? Was it not?
Your Honor, the plaintiff has not appealed the decision, the district court's decision that April 9th was the date of the FMLA interference. And so employers are entitled to take into account conduct that occurs before FMLA interference because, as the district court explained, a damage cannot occur because of an FMLA interference issue if it's based on conduct that predated the FMLA interference.
But putting aside, since justice may not have anything to do with the facts of this case, but just sort of, so indulge me. Didn't they know that she had depression? Why wouldn't it start when they were aware that she should have been told? Wasn't the interference when you're not told? Starts when you're not, it's not?
As we have argued throughout this litigation, the folks at the agency were not aware that there was, that the cause of this egregious conduct that required the EAP referral on April 9th was because of depression. And that was fully litigated in the prior appeal, Your Honor. If there are no further questions, I see I've exceeded my time, and I would ask that the courts affirm on either of the bases raised in our brief.
Thank you, Ms. Lopez. Mr. Boston, you have some time reserved.
Thank you, Your Honor. First, it sounds like the appellee agrees with us that it's a matter of law. Whatever the court decides on the burden of proof, we prevail, we go back on a remand. If we win on that issue, and we don't prevail, obviously, if we don't win on the issue. I would say to Judge Quattlebaum's question earlier, I'm looking at the court's opinions, JA 318. What the court was focused on, and the court, quoting the court, the judge said, the evidence establishes that the proximate cause of Hannah's non-selection for the cyber position was Ewing's negative impression of Hannah. It's very clear to me that she was making the decision as to proximate cause. Proximate cause should be considered at the liability stage, as I stated earlier. And at that stage, the burden should have shifted. If I can speak to some of the questions of the court on this issue of factual findings of the lower court, this court said in the Rita Darris v. Wilkinson case, it's 990 F. 3rd at 356, a 2021 case, that when a factual finding is made in the application of an incorrect legal standard, it is not to be accorded any deference by this court. And there's virtually no question that the trial court, the judge lodged all of her factual findings in this proximate cause burden. She was saying, you've got the full burden to show but for cause, plaintiff, and under that under that lens that the judge was operating under, she She came to the wrong factual findings. And so they should have no deference in this court as to factual findings.
Is there a case, counsel? I mean, I understand your point that proximate cause, we've talked about it earlier, is this kind of, is it liability, is it damages? Is there any case that you have that talks about not whether you violated a statute? Let me phrase it that way. Sometimes saying liability damages may confuse things, but where the issue is not whether the statute has been violated, either FMLA or ADA or the retaliation of Title VII, and we're talking about the damages caused by it. Whether is there any case in that context that supports your argument?
Your Honor, I'm not familiar with any particular case off the top of my head.
Okay.
I believe my argument aligns with all general principles of tort law and everything else. This is not a damages question. When you're looking at damages, then it's really like a quantum question. The judge wasn't, that's not what she was considering. She wasn't like, should you get 0 damages for the cyber position?
I'm sorry, go ahead.
Yeah, so I mean, it's just not that kind of question. It was a proximate cause, meaning, did we show, the judge was thinking, did the plaintiff show that the proximate cause of her cyber damages was this interference back in April? That's what the question was, and that is a liability question under all the court's tests for FMLA interference when they look at the elements. It's interference that caused harm, the third element of a liability question. That's where the judge was. Now, the record's confused. I can understand, and the trial judge said below, no, it's a damages question. But that just wasn't right. That was incorrect as a matter of law, Your Honor. Again, if I may say, and speaking to the facts, if the burden flips, then the question is, did the employer show, did OD&I show, that they would have made the same decision? And the only evidence on that issue was twice Mr. Ewing was asked at trial the question, and I'll quote, if Hannah had eliminated her attendance and reporting issues in April of 2015, you likely would have hired her for the cyber position in June, correct? This is at JA 87. He says, that would have been a real possibility. And then he followed that up, JA 89, by saying to the same question, I don't know, I really don't know what I would have done. It's as if Mr. Ewing was saying, if the burden is on us, we can't meet it. There's not a court in this world that should find under those facts, if the burden was on the employer to show they would have made the same decision, that they could have gotten this wrong. And so I would say this court should not remand the case. It should rule in our favor if the burden was truly on the employer, and then it should send the issue back for that question of damages. What are the quantum of damages? Other than that, the case should be ruled on at this level. Unless the court has any further questions for me.
No. Thank you, counsel. Thank you so much. Thank you both. We'll come down, Greek counsel, and proceed to our next case. Ms. Podolsky, when you're ready.
May it please the court, Gail Podolsky from the law firm of Carlton Fields, representing defendant appellant Dewberry Capital Corporation. Dewberry Capital is here today to ask the court to reverse the district court's summary judgment order and remand this case back to Judge Trenga, who is the newly assigned district court judge to this case. The district court's summary judgment order failed to apply the correct summary judgment standards. The judge's opinion improperly weighed the evidence, made credibility determinations, failed to view the evidence in the light most favorable to the non-party, and failed to consider evidence that directly contradicted the court's key conclusions, including the parties' agreement to coexist in the marketplace. The district court also completely ignored the fundamental element in trademark infringement cases, priority of use. The summary judgment record and briefing demonstrated significant issues of fact, including the hotly contested issue of likelihood of confusion. These errors initially resulted in the district court finding Dewberry Capital liable for trademark infringement and breach of contract as a matter of law. The errors were further compounded in the damages trial and the disgorgement award, the scope of the injunction, and the district court's finding of an exceptional case and willfulness.
Didn't appellant itself say that there was likely to be confusion in the, in its counterclaim in the prior litigation, which resulted in the confidential settlement agreement?
The parties did dispute trademark infringement back prior to the coexistence agreement, but there were disputed issues of fact at that time. What were the relevant services, as
But
well as...
causing confusion was not one of them. In the appellant's counterclaim, appellant wrote that the marks, quote, so resemble appellant's Dewberry Capital marks as to likely cause confusion.
Yes, Your Honor, the counterclaims were ultimately dismissed by the trial court, but I think that, at least in this current case, the prior
I'm talking about the
litigation-
2006 litigation.
Yeah, the prior
Way back,
litigation-
even before this litigation started, appellant agreed that there was, or claimed that there was likely to be confusion in its counterclaim. And it wasn't dismissed, that was settled based on the confidential settlement agreement, which you call the coexistence agreement.
Yes, Your
for some
Honor. I mean, the
reason.
substance of the agreement is, from trademark purposes, a coexistence agreement. Yes, the parties disputed the trademark infringement and likelihood of confusion. After the record was developed, they settled. And
You keep saying the parties disputed it. I'm saying appellant did not dispute it. Appellant is the one that wrote that there's likely to be confusion in its counterclaim in 2006.
And that was with respect to Dewberry Capital versus Dewberry Engineers. And this case is concerning different marks. And there are also the fact that, again, the record came forward. And I think the evidence, based on the current record, shows that there are disputed facts on likelihood of confusion. So turning to the trademark infringement claim, we have, again, priority of use. So priority of use was completely ignored by the district court, and this alone warrants reversal. Priority of use is a threshold element of any trademark infringement claim, and the district court failed to consider this at summary judgment and in entering the injunction. Prior use and scope of use is a question of fact. And the facts is that Dewberry Capital first used its mark in 1989. Dewberry Engineers trademark registrations claim a first use date of 2003. Those facts alone warrant reversal, and especially when you're drawing all reasonable inferences in the non-movement's favor. If we turn to likelihood of confusion, as this court knows, likelihood of confusion is a well-established to be a question of fact and inappropriate for summary judgment. It's 9 factors, but today, due to time, we'll focus on a few. First, turning to the strength and distinctiveness of plaintiff's mark. In the summary judgment order, the district court acknowledges that Dewberry is both a fruit as well as a surname. But without any citations to the record, it summarily concludes that plaintiff's trademark does not suggest a surname and that the marks were arbitrary and conceptually strong. But in reaching this conclusion, the district court again failed to construe all reasonable inferences in the non-movement's favor. Surnames are never assumed to be distinctive. There are also numerous third-party uses of Dewberry and marks that end in Dewberry that were presented, and that's at JA 1742 through 1757. We also have the fact that the plaintiff consented to defendants' uses of Dewberry, including one that had the Dewberry fruit in Dewberry Isle. These were consented to by the parties. We also have the fact that over 4,000 people have the last name Dewberry. Dewberry engineers outside of this litigation, there is not evidence presented that they police their marks. In fact, there's contrary evidence that they failed to police the marks. And Dewberry engineers operates in limited markets. And the district court failed to consider this evidence, simply looked at the trademark registration and ended the analysis there. If we look at the similarity of the marks, I think that the response brief that was filed really shows the difference of the parties' marks. If you just look at the marks as a whole. So one, you have a fruit, on the other, you have a stylized D. The fonts are different. The typeface is different. Even Dewberry in the marks are different. Our client uses all caps, they do not. And then the design marks are the dominant feature in our client's mark. The stylized D is double the size of the Dewberry fruit. And then you tack on the fact that we use more than just Dewberry. With all reasonable inferences in my client's favor, there are visual differences that precluded the court from finding similarity of the marks. But you don't stop the analysis there, you look at the marks' meanings. Well, the district court claims that Dewberry on the plaintiff's side is a fruit, and our Dewberry is a surname. So they have different connotations. But district court didn't look at that. All of this leads to different commercial impressions. But you can't forget about the coexistence agreement. The parties divided it up. We got to use Dewberry Capital, they got to use Dewberry. So substituting one generic term, Dewberry Capital for Dewberry Group, doesn't change the overall commercial impression of the mark.
Counsel, let me interrupt you. I mean, you've been talking up until now about, facts outside, I guess, of the settlement agreement. I'm just trying to get square in my head the extent to which we can use a settlement agreement. I guess we can use, it's evidence that's introduced. I'm just trying to think if how that necessarily cuts in favor of your argument.
So yes, the document's called a settlement agreement, but the actual terms of it is a coexistence agreement. It defines when and how the parties can use their respective marks. So that's a clear, in trademark world, how we deal with issues when there are, marks that people disagree on. And so the parties carved up things. And the agreement says that my client may use Dewberry Capital in connection with real estate development services. Uses the word may, not shall, may. And then it also said that our client, they were not going to object to our client's use of multiple different variant Dewberry marks, Dewberry Sessinger Holdings, Dewberry Isle, and several others. And so, yes, again, it's a title of the settlement agreement, but in reality, it's a coexistence agreement.
Does that matter? I mean, does it matter if it's a settlement agreement versus, there was a lawsuit. Anyway, I don't want to split hairs on. I can't imagine whether we call it a settlement agreement versus a coexistence agreement is the issue, is it?
No, Your Honor, it's not the issue. But it is an important factor that the district court ignored in its summary judgment order, except when it came to the intent prong. When it came to the intent prong, the judge was all over the coexistence agreement. You knew about Dewberry Engineers marks. You signed this coexistence agreement. But the fact that my client knew about them is not the end-all be-all on the intent prong. And the coexistence agreement is, from our perspective, at summary judgment, construing all reasonable inferences in my client's favor, an admission from them that there's no confusion when using Dewberry Capital, that the parties' marks are different, that the services are different, and that there's not going to be confusion. And there's even a provision in the agreement that talks about when confusion occurs, that that the parties have to notify each other, but they weren't notified of confusion. The instances of actual confusion.
What about all those cease and desist letters?
Well, the cease and desist letters weren't based on actual confusion. They were based on the objection to the new branding. And so, yes, they filed a cease and desist letter. We responded.
Letters, 3 of them.
Yes, Your Honor. There was an exchange of letters. Then we battled it out a little bit before the USPTO. And 2 of the marks that my client filed at the USPTO were actually granted in the sense of the substantive examination was permitted. And the trademark office said these are entitled to registration. But then the other side filed letters of protest. They yanked those back. And there was never a final determination on whether the marks were confusingly similar. And so in terms of the cease and desist letters, my client has every right to argue that it's non-infringing. The settlement agreement didn't prohibit it from doing that. It didn't prohibit them from changing one generic term to another. And based on the factual records and the inferences that have to be drawn in my client's favor, there weren't facts to support summary judgment on trademark infringement.
So counsel, what if, hypothetically, what if I agree with you, or we agree with you, that there may have been a question of fact on trademark infringement, but we don't think there's one on breaching the agreement? What do we do with that situation?
So in that situation, the damages award has to go away because the damages award is solely based on disgorgement, and disgorgement is not available in breach of contract cases. And even if the court were to find liability on breach of contract, which we obviously dispute at the summary judgment level, there's still no damages. They never established any damages. The only theory
The district court said they were damaged. It didn't make a damages finding on the breach of contract case. Would we not be required to send it back to the district court to assess damages for breach of contract?
I don't believe so, Your Honor, because we did have a damages trial. And they unilaterally chose just to go up on trademark damages. They made that decision. They could have tried to proffer breach of contract damages.
So your position is there's no, the district court awarded liability under both breach of contract and trademark. On the damages trial, the only evidence presented was related to the trademark violation?
Yes, Your Honor, that's our position. And sticking with the breach of contract, again, we were at summary judgment when this was decided. And we previously spoke about the provision of the may versus shall. And our position is, under the law, my client was not prohibited under the agreement to change its name. And so that was an error to find that that was a breach. And as far as the other breaches, there still are disputed issues of material fact for those as well. The district court completely ignored our expert's opinion that these were not architectural and engineering services. No mention of it. The district court weighed the evidence all in Dewberry's favor, made credibility determinations when they shouldn't have, and that resulted in a massive windfall at the damages trial. What we are asking for in this case is that the summary judgment order be reversed and the case be completely remanded as a whole. There should not have been liability, and there certainly shouldn't have been the substantial damages award once you add attorney's fees and costs was almost $48 million when there were no lost sales, no lost customers, no reputational harm, and my client didn't make any money. So to have $48 million tagged to my client when there were no profits to speak of from my client and no harm is unjust and also a complete windfall and violates the standard principles of the Lanham Act. Just to, in brief conclusion, again, we are asking the court to remand, reverse the summary judgment orders, and allow this case to proceed to trial. And I will reserve my remaining time.
Thank you, Ms. Podolsky. Mr. Lynn?
Good morning, Chief Judge Gregory. May it please the court. Albert Lynn on behalf of Dewberry Engineers. Dewberry Group would have this court believe that the district court below got nearly everything in this case wrong. But as the district court said, in reducing my client's requested attorney fees, and I quote, "This case was relatively straightforward. It did not present novel legal questions nor complex factual issues." If I may, I'd like to start with the breach of the settlement agreement, because the settlement agreement is where this entire saga began. The district court correctly concluded on summary judgment that the Dewberry Group independently violated 4 provisions of the confidential settlement agreement, B2 and B3 together, which govern the use of Dewberry Capital with respect to real estate development services, B6, which bars the use of Dewberry Capital with respect to architectural and engineering services, and B10, which required the continued use of the column symbol, quote, "where feasible." Dewberry Group has argued here she does not contest any of the evidence that formed the basis of the district court's opinion. She raises this notion of, she invokes the phrase question of facts repeatedly as if it has some talismanic significance, but as this court knows, questions of fact can be resolved at the summary judgment stage if, when you look at the record as a whole, especially the uncontroverted evidence, no reasonable jury could rule in favor of the non-movement.
Counsel, what
Yes,
if,
sir.
yeah, I don't mean to, I want to let you finish on liability, but I'm kind of jumping ahead. I want you to assume I agree with you on the contract case, there's no genuine issue of material fact. Did the district court do anything on damages? It said you had incurred damages, but did it issue a damages award on the breach of contract case?
It did not, Your Honor. It issued the injunction, which I based on both contract liability.
Well, I
and-
think the injunction, I mean, if I recall, I think there can be an issue about whether you can get the injunction as a breach of contract. But if I remember the order, it was relying on the trademark violation for the injunction. You know the record better than me.
I'm fairly certain it would rely on both for it,
Okay.
both
I
the
thought it was
infringement.
the other. I'll double check.
But as to your question on the damages, we agreed with the other side. The damages were based on 1117A
Right.
of the Lanham Act, the disgorgement of profits. So
So what if, and I asked your colleague this same question, what if I agree with you, no genuine issue of material fact on contract, but I think there is one on the trademark violation? What do we do there with the contract claim?
Your Honor, I think you affirm the liability on the contract claim. I think you can, and this gets to the question we talked about on the record on the injunction, I think you can maintain the injunction. The terms of the injunction track many of the terms of the confidential settlement agreement. And then I do think the disgorgement of profits goes away because that was awarded as a result of the trademark infringement. But as I'll get to, and I can turn to it now if you would like.
You go whatever order you want. I just wanted to ask you that question.
And I have a question about the disgorgement of profits, and you're saying that goes only to the trademark infringement, correct?
Correct, Your
Not the breach of contract. Is there a causation requirement before damages for disgorgement of profits is entered?
There is not, Your Honor, and that's because of the way the statute is worded, and this court has recognized it, as have many others. So there's two parts to 1117A. You can get damages, literally the word damages, which is actual damages, or you can be awarded profits. And we were awarded the disgorgement of profits under the profits piece of this. This court's decision in Georgia Pacific identifies the two different avenues for disgorgement under 1117A. The profits piece of it has a very specific sort of burden shifting approach to it. We, as the plaintiff, need to show their profits. They then carry the burden of showing, Your Honor, this gets to your causation question, which costs are not attributable to the infringing marks, and that then gets deducted from what we showed as profits. There's a further piece of it, which is where we think the bulk of this comes from, and it goes on to say, it says, if the court shall find that the amount of the recovery based on profits, so once he's calculated the profits, is either inadequate or excessive, the court may in its discretion enter judgments for such sum as the court shall find to be just.
But before the kind of mechanical approach that you outlined from 1117, there's the phrase subject to equitable principles. And so that applies to the profit analysis, it seems to me, reading the text of the statute. We then have our, I think, synergistic case that lists some factors, and certainly at least a factor is whether there've been any diverted sales. I'm not sure we've ever adopted what the IP world calls the traditional test or the modern test or those things that are talked about in general. I was trying to figure that out a little bit myself. But to Judge Thacker's question, I think the presence or absence of actual damages is certainly relevant, at least under the synergistic case. Would you agree with that? I mean, it's a factor in there. Are there any diverted sales?
Yes, it is a factor in there, and so just to back up for a second, I mean, I think there's two pieces to the disgorgement analysis. The synergistic factors, I think, are this court's way of kind of organizing the assessment of whether, right, a disgorgement is permissible at all. There's the separate question of once you determine whether the disgorgement is permissible, how much can be awarded. And I think that gets into the profit calculation and then the awarding of the additional sum as the district court determines in its discretion it's just. And when you apply the synergistic factors, we can talk about that now. I mean, this court has never said that all of the factors are required. In fact, in synergistic itself, it noted that the factor of willful infringement didn't have to be satisfied. And so we think that at least 4 of them are satisfied here. Intent, and these are all findings based on findings of fact of the district court. I think it's important to remember that the disgorgement of profits piece of this followed a 3-day trial with multiple witnesses and a lot of documentary evidence. So the district court made a finding of intent, made a finding that the injunction was not a sufficient remedy, made a finding that there was no unreasonable delay, and made a finding that public interest was served by the deterrent effect here because, again, we had a confidential settlement agreement that they didn't abide by and blew right through. Yes, Your Honor.
True, but it says whether sales have been diverted, and then it makes this finding that the court has already established that the parties operate in overlapping markets, which, yeah, I'm not going to go back, but that seems at least debatable. But I'll be glad to talk to you about that. Y'all do different stuff. But even assuming that, then it goes on to say because they're in overlapping markets, that shows there have been diverted sales without identifying any diverted sales. So it's like, okay, they're in overlapping markets, putting aside the fact that y'all are third-party engineering services and they're real estate developers. It just assumes they're diverted sales without identifying one.
So, Your Honor, there's a lot in that question. If I could reserve this sort of services question, because I have an answer for you on that as well.
Okay.
On the diverted sales, so I mean, this really gets to, I think, what are the synergistic factors doing under that prong? And so I think what synergistic says is whether the plaintiff lost sales as a result of the defendant's trademark infringement activities. That, I think, gets to the lost sales and the extent to which the plaintiff had entered the market area where the infringement occurred. I think his finding about the overlapping markets goes to that second piece of it. And if I could just put a pin in that and come back to it, because I want to answer your question on diverted sales. I think, Your Honor, to the extent synergistic suggests that diverted sales must be shown, right, that there has to be a causation element, this gets to Judge Thacker's question, that is inconsistent with the statute. This court in Exclaim Marketing, this court in Shell Oil, and multiple other circuits, there's no split on this question, agree that under 1117A, you can get either actual damages or profits. And the profits analysis does not require the plaintiff to show causation. That burden falls to the defendant. So, is it relevant to the synergistic factors? Yeah, synergistic seems to say it is relevant, but I don't think you can say that there have to be actual damages or a straight line to lost sales, because that would not be consistent with the statute or this court's case law.
So assume, yeah, we have kind of the same situation, and at the same time, Dewberry Group infringes um, they, um, Mr. Dewberry from Dewberry Group, has a client that's a long-lost uncle who wants to develop a bunch of real estate. And all of a sudden, they make $50 million because the guy's family starts using them for real estate development. At the same time, they are violating the trademark. But looking at that, the additional revenue has zero to do with the violation of the trademark. Your position there is you get that profit, right?
Our position is that the burden then shifts to the defendant to show that there is no causal link. That's what the statute says. It says that, I want to make sure I find it. In assessing profits, the plaintiff shall be required to prove defendant sales only. Defendant must prove all elements of cost or deduction claimed. And the case law spells out what that means. And that means that the burden of showing that there is no causation link between the infringing marks and the sales falls to the defendant.
And which case law is that?
The Exclaim Marketing case talks about that. There are ones from, I can point you to some from other circuits as well. Exclaim Marketing is this court.
That's fine. This court's all I need.
And did counsel on that point, I think, I may be wrong, but I think Dewberry Group, I'm calling it Dewberry Group versus Dewberry Engineering, just to keep it straight in my head. Did Dewberry Group, and I'll ask your colleague this on her remaining time, introduce evidence that the profits, I know they challenged the third-party corporate issue, but putting that aside for the second, did they produce evidence that the profits obtained were not related or causally connected to the mark, to the violation of the mark?
The short answer is no. They made the categorical assertion that all of these revenues should be out, and this is at her report at JA 4457. Therefore, I am not calculating defendant's profits at this time. And the district court noted that in the trial on damages, she was asked about whether she had done this sort of itemized deduction, and the expert Miller admitted that she hadn't. The district court relied on that. We pointed it out in our opposition brief, and my friend in the reply didn't contest that.
Can I shift to another damages? You got something you wanted to
Well,
say?
I did want to get to the services and the market question just very quickly to Your Honor, respectfully disagree with sort of your perception of the evidence here. I think the uncontroverted evidence shows that they are a subset of our universe. There's a sealed declaration, the Maxwell Declaration, which I won't read out loud in public, but Your Honor, if you look at that declaration, it explains what we do, which is everything related to the built environment. And so real estate development services are a piece of what we do. The Legarata Declaration also talks at length about Dewberry Real Estate Services, which uses the marks at issue here to do real estate development services. So we do architecture, we do civil engineering, we also do real estate development services, and we're in the same market. The uncontroverted evidence shows that we are in all 50 states.
Yeah, but isn't there at least, I mean, fair, if I overstated it, I appreciate your response, but I mean, the district court granted summary judgment, and it seems like, there's some, it's not like y'all line up one-to-one. Anyway, I don't want to, get too much in the weeds. My question is maybe not whether you're absolutely not in the same market, but whether there's a question of fact as to whether you're in the same market.
I don't think so, and Your Honor, I know you had another question on damages, but this gets to likelihood of confusion.
Right.
And I think, one, on similarity of services, which is the factor that we're discussing here, I think, as we've discussed, I think there's uncontroverted evidence that we do the same thing. They say there are questions of fact. That's the phrase that she uses. But she does not point to, you can look at the sites that she points to in her reply brief. None of them contest our evidence that we perform real estate development services. But the other point, Your Honor, on similarity of services is that the case law doesn't require either identical services or even direct competition. And that's from this court's case law. What it says is that you can have sort of similar services, but also complementary products or
Right.
services, right, are particularly vulnerable. That's the ComSet case.
And that's, the interesting thing, I mean, I think that's fair. We have this, we got, I think, I can't remember how many factors, I think 10 factors.
Nine, Your Honor, under
9
pizza revenue.
factors, appreciate. The general law is those are questions of fact, and we got a recent Variety Stores case involving the same issues that makes that point pretty emphatically. And so you got are there questions of fact related to each of the 9 factors? And then you got B, how do you apply all those factors? And the district court, of course, said that there's no genuine issues of material fact. But anyway, I know your position on it. That just seems like a lot of weighing, even of the factors, even if you assume you're right on all the factors.
True enough, Your Honor, but this court has also affirmed summary judgment on likelihood of confusion a number of times, including in the RxD case just 2 years ago. It also did it in the Lone Star case, which I think is particularly notable because there, this court concluded that the district court hadn't even gone through the Pizzeria Uno factors, then declined to remand and said, we can look at the record and conclude on the summary judgment record that no reasonable jury could not find likelihood of confusion. And just to, again, I don't want to lose your other damages question, but on likelihood of confusion, I mean, there is similarity of services, which we think we have identical and in direct competition, but I think even complementary services, and I think it's very difficult to dispute that they are complementary services in the same sense that was described in ComSet. But the other factors are the ones that this court has described as paramount and important. Actual confusion, for example. We have a survey, uncontroverted. They didn't put in contrary survey evidence. They tried to get it struck under Daubert. That failed. They haven't appealed that ruling. So the survey stands alone as the only survey evidence. It found 20% confusion rate. This court in the RxD case quoted the Rosetta Stone case saying that 17% in a survey is, quote, clear evidence for purposes of summary judgment, Your Honor, to get to your point, that's so overwhelming that no reasonable jury could go the other way on actual confusion. On intent, Your Honor, the district court described multiple red flags. I think he described them, I would call them stop signs, that they just blew through. 3 cease and desist letters, the original confidential settlement agreement, the PTO's multiple rejections. But for me, Your Honor, I think the one that's the most compelling is the fact that when they decided to rebrand, John Dewberry, the owner of Dewberry Group, didn't even tell his general counsel about, much less the existence of the confidential settlement agreement, even the fact of the prior litigation. And that's undisputed in the record at JA, I think it's 3826. There's a letter from John Gross, the general counsel, apologizing to my client, saying that he didn't even know about the prior litigation until we had mentioned it to him. So you've got actual confusion, you've got intent, similarity of the marks. Your Honor, I think my friend misunderstands the case law. If you look at the Pizzeria Uno case, it says you just look at whether the marks look the same. In Pizzeria Uno, this court found Pizzeria Uno and Taco Uno to be similar marks because of the use of the word Uno. If those two are similar marks, surely Dewberry, which is our mark with a berry, and Dewberry Group are similar marks for purposes of that factor at the summary judgment stage. I think when you put these factors together, you find, Your Honor, it's like the RxD case. It's like Lone Star. It's one of those cases where there's so much evidence and it's undisputed that you can affirm a summary judgment finding of likelihood of confusion. I'm sorry, Your Honor, you had a damages question. Did you?
I do, but I've been monopolizing we'll add the yield before. Okay, thank you. We have this issue about profits from related companies being considered and used to establish the profits of the defendant. I know the district court says it's not piercing the corporate veil, but I don't know how that's not effectively piercing the corporate veil. I mean, you are awarding to your client money that is in the, custody of separate entities. And so it seems like both your expert and the court say, look, I'm just looking at this kind of in a big, they're all related, sort of way. And they are related, I don't doubt that, but related companies establish separate entities all the time. And courts just don't disregard that unless, Pearson, the corporate veil factors are established, which isn't done. I read the Fifth Circuit's Rice case, and so I see that facts are kind of different, but they were, that arguably provides some support. Is there anything else besides that? Help me with that because it seems odd to me that you can award damages that necessarily would be paid, maybe that's the point, by a third party, and they're not parties in the case.
I see my time has expired, Matt. So, Your Honor, two answers, and the first is where you left off. The distinction is the judgment wasn't ordered against those other entities. They're not required by this order to pay. They haven't been found liable. The $43 million was the district court, relying on our expert report, used the revenues and the profits of those other related entities as a benchmark, a measuring stick, if you will, for the exercise of his discretion under 1117A, and said, this is what is just, right, beyond the profits of Dewberry Group. This is what is just under the circumstances. And to your point, Your Honor, we may have a collection problem, right? And that's not before this court, and that's a totally separate issue. There may have to have been veil piercing to actually get the profits from those specific entities. But that's not what was awarded here. The $43 million disgorgement of profits judgment was awarded against Dewberry Group. And so we have to go out and get that now if this court affirms it, right? Then I mean, that's the question. But there is no veil piercing that's required because no liability was ordered against them. And the second answer,
Go ahead.
if the court will indulge me, is if you ask for other cases. If you look at the Cars for Kids case from Third Circuit, 8F4th 209, you look at Max Rock, 40F4th 454. And I point to these other circuits because this court doesn't have a lot of case law in 1117A. Those courts talk about that discretion. And they say, one, not just a reasonable reason for exercising discretion, but really the very purpose of that discretion is to get after, and here's the quote from Cars for Kids, true profits. And from Max Rock, that discretion is available for concern that the award does not encompass the defendant's full profits.
Did they use profits from related entities?
Cars for Kids actually went the other way. It said, if it had been true profits, that would have been a good rationale for exercising this discretion. In that case, the district court did something that the court found to be punitive. And my point is simply, those cases explain the purpose of this discretion, where the judge looks at the profits that have been shown for the defendants and says, that's not just in this circumstance. I'm going to increase that number, and one reasonable basis and non-abusive discretion basis is to say, what do I think the true profits are? And he had an evidentiary basis for doing that here and said, that's what I'm going to award. I'm not going to order it from these entities, right? That's why no veil piercing is required. But I am going to award the judgment against the defendant. Thank you, Chief Judge.
Thank you. Ms. Podolsky, you have some time reserved.
Thank you, Your Honors. First, I would like to discuss the disgorgement of profits and the causal connection. So in our brief on pages 39 through 40 of our opening brief, we cite a U.S. Supreme Court case that says the plaintiff, of course, is not entitled to profits demonstrably not attributable to the unlawful use of this mark. And that's Mishawaka Rubber, 316 U.S. 203 at page 206. And there are additional cases that similarly hold this. So it is our position that the law is clear on this, that there has to be a causal connection to the purported profits. And focusing on the first prong, which is disgorgement even appropriate in this case? If the district court properly went through the disgorgement synergistic factors, it should have found that disgorgement was not appropriate. When you're looking at the intent to confuse or deceive, you have to look at, was my client trying to capitalize on Dewberry Engineers? And there's no evidence to support that. My client has been in existence for over 30 years. It's his namesake that matters to him. He doesn't care about Dewberry Engineers. He proffers everything by his name. It's his company's. It's John Dewberry, not plaintiff, which was Sid Dewberry, even though they are distant cousins. You know, Dewberry's customers, it was an important factor to know that they were all John Dewberry's related entities. It's not like they were going out into the marketplace advertising. They were a corporate shared services. The other thing, as Your Honor previously mentioned, is there's no evidence of diverted sales. There is an adequate remedy, even though you know, we don't think that they proved infringement, but in this case, when you have no diverted sales, no lost sales, and no profits from my client, an injunction would have been sufficient. But that's not what happened here. We have
So, counsel, in the damages trial, I mean, we look at the summary judgment liability, obviously under the genuine issue material fact, but aren't we in a different world in awarding damages? I mean, you got various factors that can be in, and we might disagree with them, but are we in a abuse of discretion world in the damages award?
So under synergistics, an award of damages is reviewed abuse of discretion. The amount awarded is reviewed for clear error, and the method for determining the award is de novo.
Right, but
Clear as mud.
well, I think that makes sense. I mean, the method here is application of the synergistic factors, right?
Yes, Your Honor.
But it's not, okay, I hear you.
I'm sorry.
Yeah, good.
Doesn't the Supreme Court case that you cited put the burden on your client, as opposing counsel argued?
The burden of proving costs is on my client. And even if the burden was for the causal connection, even if the burden was on us, we demonstrated significantly that there was no causal connection between the revenues of non-parties that aren't being accused of using the marks and those profits and the alleged infringement.
Wait, what's the evidence? Just tell me the actual evidence, not that you did it. What's the evidence?
So the evidence is in the trial record. Our expert, Lisa Miller, went through and described in detail that all of the leases that were the basis of the disgorgement award were executed or discussed prior to the alleged first use of the alleged infringing marks. So what we're talking about here, the revenues generated are from leasing office space in non-party buildings. And that revenue went to the non-parties, and the district court disgorged that revenue and gave it and awarded it to the plaintiff. So here you have long-term leases in Class A, office buildings that the contracts existed prior to the first alleged infringement date, or that the communication started. There's also substantial evidence. She had a whole chart where she said exactly why these damages or why these revenues are not attributable to the alleged infringement. And additional evidence that she supported was the fact that a lot of times when the tenants came, they came through a third-party broker, and they were negotiated through a third-party broker. Dewberry Group had nothing to do with it.
Was that expert's opinion admitted into trial?
Yes, Your Honor. The other thing that our expert talked about at length was the revenues associated with transient parking. So my client had, parking lots that people would come in and park when they wanted to be in Midtown in Atlanta, Georgia. And the district court found that the expert testimony that was not rebutted that said, people pick parking lots based on the location of where they're going. They don't pick it based on a trademark. The district court said that just wasn't believable and found that revenues generated from parking in a lot were somehow attributable to the infringing marks. And again, their expert just assumed that all of these profits there was a causal connection. There was no evidence that he reviewed. He went off a chart that was provided by plaintiff's counsel in determining that, profits earned by 13 non-parties somehow should be impugned to Dewberry Group because Dewberry Group provides some property management services to companies owned by John Dewberry. I also wanted to briefly touch on, the other errors on the disgorgement award. In addition to the synergistic factors and no causal link, as was previously discussed, here we have a complete windfall based on non-parties' profits. And yes, there is the American Rice case, but in that case, we're dealing with a product. And a product, you can make that causal connection because the product has a product name, and that's the alleged infringement. Here we're dealing with services provided to parties that are related to my client. So the facts in the American Rice case and the other cases that the district court relied on, are very distinguishable. The other thing that the courts look at when assessing profits is they look at arm's length transactions. And so if you're going to pull from a non-party and find the accused infringer and disgorge those profits from the non-party, there's got to be some alter ego, veil-piercing, improper allocation. And here, there is no allegation of alter ego, veil-piercing, or anything of that nature. And a case that I think is much more on point is Globefield versus Element Spirits. It is a California case that was affirmed in the Ninth Circuit. It's 2017 Westlaw 6520589. Their plaintiff tried to argue that a non-party was an affiliate of the alleged infringer, and therefore all of the sales of the non-party should be disgorged, and the district court said no, which was affirmed. The finding of infringement was only against the defendant, not the non-party, and the district court correctly said that it lacked jurisdiction to order disgorgement from a non-party. I see that I'm way out of time, I apologize.
All right, thank you, counsel. We will ask clerk to call a brief counsel. Go ahead.
Thank you, Your Honor. Tiffany Yang from the Georgetown Law Center on behalf of Mr. Brown. With the court's permission, Brandon J. Brown, a third-year law student, will present the argument on Mr. Brown's behalf.
Thank you. Mr. Brown?
Your Honors, may it please the court. This case concerns the erroneous denial of compassionate release for Mr. Brown, who currently serves a 57-year sentence. 30 years of his sentence are for convictions that carry just a 10-year mandatory minimum today. That major sentencing disparity is an extraordinary and compelling reason for release, and the district court erred by ignoring it. Given the gravity of that error and the 3-year delay in Mr. Brown's case, this court should remand with instructions to grant immediate release. The district court's failure to consider the 20-year difference between Mr. Brown's current sentence and the sentence that he would
Why
receive.
wouldn't we remand it and have the district court consider that sentencing disparity in the first instance, since the district court did not consider it at all the first go-round?
Well, first, this case should not just be remanded for consideration of whether the stacking is an extraordinary and compelling reason anew, because this case was already sent back to the district court once for consideration of what this court said in McCoy, which is that stacking can be an extraordinary and compelling reason, but also because it is not just that Mr. Brown has stacked 924C sentences that result in a 20-year disparity, but it is also because he has significant medical vulnerabilities and also has shown extensive post-sentencing rehabilitation, all things that factor into the totality of the circumstances analysis as to whether he has shown extraordinary and compelling reasons. And so because of that, this court should remand with instructions to grant immediate release, or at the very least should remand with instructions to find that Mr. Brown has made a showing of extraordinary and compelling reasons, and then for full resentencing under the 3553A factors. It is not just the gross disparity of 20 years that affects Mr. Brown that is an extraordinary and compelling reason for release, but it is also the sheer and unusual length of that 30-year sentence for 2 consecutive 924C convictions. As this court stated in McCoy, a stacked sentence that exceeds the average punishment imposed for more serious crimes also supports release. Mr. Brown's 30-year stacked sentence for possessing a weapon exceeds the national sentencing average for manslaughter, murder, and also kidnapping. And further, his stacked sentences show a disparity between him and the rest of the co-conspirators in the indictment. The district court did not only not address Mr. Brown's stacking, his most important claim in its extraordinary and compelling reasons analysis, but the district court also committed legal error by failing to consider Mr. Brown's stacked sentences in the 3553A analysis. The First Step Act was an enormous change in law, and by not mentioning that, the district judge, essentially it was his entire one-paragraph analysis in 3553A was tainted, and that can be seen line by line of that analysis. First, in 3553A, the district judge talks about the length of time that Mr. Brown served, which the judge says is 11% of 57
I
years.
want to make sure I understood something you said earlier. Did you mean to say that this was sent back once before for the district court to consider the stacking issue as extraordinary and compelling?
Yes, this was sent back for the district court to consider this court's opinion in McCoy, where the court affirmed multiple defendants who had stacked sentences. The court affirmed the district court's decision to grant their motions for compassionate release. And so on remand, this court gave the district court here instructions to consider what McCoy said. And the fact that the district court did not consider it is a reason to remand this for finding of extraordinary and compelling reasons. But back to the 3553A analysis. The district judge mentions Mr. Brown's time served, which he says was 11% of a 57-year sentence, which the district judge says did not allow adequate deterrence. But if stacking were considered in that computation, it would show that Mr. Brown's total sentence would be 37 years, not 57 years. And so at the time of the denial of his compassionate release motion, Mr. Brown would have served nearly a quarter of his sentence. But because the district court did not consider stacking, that computation is flawed. The district judge also mentions that Mr. Brown's gun convictions pose a risk of danger to the community. But via the First Step Act, Congress has decided that 10 years is enough to mitigate 2 consecutive 924C gun convictions. And Mr. Brown, as of last fall, has served 9 years of his sentence. And when you add in the good time credits, which are about a year and 4 months, Mr. Brown has effectively served that 10 years already. And so any mitigation concern or adequate deterrence concern has already been met by Mr. Brown. That is not reflected in the district court's opinion. Also, 2 pertinent 3553A factors are not mentioned at all in the district court's opinion because of the fact that the opinion disregards stacking. That is the need to avoid unwarranted sentencing.
In response to my 2 prior questions, I just want to make sure I'm clear about what we're talking about. Are you talking about our prior order at JA 87 to 91?
Yes, well, the district court's first opinion, which was then,
Is that the one
district
you're?
court's first denial of Mr. Brown's compassionate release motion, which this court then remanded for consideration of McCoy. On footnote
Right,
4,
okay, go ahead. Footnote 4.
yes, footnote 4, where the court says McCoy is relevant.
Right, that's not what you said to me twice. You said that that we sent it back for the district court to consider McCoy, and you specifically said to consider the stacking, because I asked you what, my first question was, why would we just order his immediate release without sending it back to the district court in the first instance to consider the stacking issue as extraordinary and compelling? And you said, your response was, because we had already told the court to do that once before on stacking. And then I wanted to make sure I heard you correctly, because I don't see the word stacking anywhere in this order. I asked you again, and you again said that we sent it back to consider stacking. And you couch it in terms of McCoy, which I understand. McCoy does say extraordinary and compelling reasons, and this stacking issue certainly may be one. But what we sent it back for was because the court didn't consider the obesity issue in the first instance, right?
Your Honor,
It doesn't say stacking anywhere.
in footnote 4 of this court's remand, it says to consider McCoy because of the severity of the defendant's section 924C sentences and the extent of the disparity between the defendant's sentences and those provided for under the First Step Act.
All right.
So that's
Thank
right.
you.
Thank you. And to get to that other sentencing factor that was not mentioned by the district court's opinion, it was the need to impose a just sentence, which today Congress has determined is only 10 years instead of 30 years for the 924C convictions. And so because the district court did not consider both Mr. Brown's stacked sentences or his serious medical vulnerabilities in the 3553A analysis, that analysis was legal error under this court's standard in Hyde, which is that district courts must put forth enough reasoning in a 3553A analysis to allow for meaningful appellate review. On the face of this district court's analysis, it cannot be determined why Mr. Brown's criminal history, which is primarily what the one paragraph focuses on, outweighs the extensive showing of rehabilitation that he made, and it cannot be compared in any way to the effect of stacking or serious medical conditions because those 2 things were not mentioned. To take some time to talk about that extensive showing of rehabilitation, which in no way is reflected by the district court's one-line sentence about appreciating Mr. Brown's service. Not only did Mr. Brown serve in prison in terms of his employment and also as a tutor, but Mr. Brown was employed for all of his confinement, working in both the library and the education department, and he was promoted to head library clerk, showing that the prison entrusted him with the responsibility of streamlining the library system for the other inmates. And this can be shown in Mr. Brown's letter motion, which starts on JA 63. Further, Mr. Brown as a tutor has helped inmates receive their GEDs. So he has not only taken numerous classes on anger management, drug prevention, and leadership, but but he has gone out of his way to use that education to help others receive their GEDs in prison. And Mr. Brown has shown an exceptional behavior record in prison with only one infraction related to self-defense. But this was severely undermined by the district court's opinion, saying that it only appreciates Mr. Brown's service.
Counsel, why is that not, at least in terms of the, post-imprisonment conduct, the mitigation type factors? I certainly realize he could have said more, but why shouldn't we read the court appreciates defendant's service while imprisoned as indication that he considered those arguments?
Because this court's precedent in Martin and also persuasively in the unpublished cases of Spencer and Gutierrez shows that when a defendant puts forth a mountain, to quote Martin, of mitigation evidence, of post-rehabilitative evidence, then simply one line does not show enough to make sure that there is reasoning as to why that evidence either weighs more or weighs less than a defendant's criminal history or any of the other factors. And so this court made clear in Martin that courts cannot ignore or severely undermine when defendants have shown extensive evidence, and Mr. Brown has shown that here. In addition to rehabilitation, Mr. Brown, in his letter motion, talks extensively about how he has worked towards a reentry plan and has shown deterrence. And that is not seen on the face of this opinion at all. Mr. Brown's aunt has agreed to let him live with her in Virginia upon release, and also he has had his brother contact 2 of his former employees, one of which has already offered him a job. Mr. Brown has also had his brother contact a local food bank and retirement home, both of which who have agreed to allow Mr. Brown to volunteer there upon release. And in his letter motion, he talks about how important serving and volunteering is in his community, and that he wants to do that to be able to show his kids that he is a role model. Mr. Brown also talks extensively about his remorse that he has, and that he takes action or responsibility for his actions, and that he seeks to serve his community also as a way of paying that sense of remorse and responsibility forward. None of these things can be seen on the face of the district court's opinion because there is only one sentence about appreciating service that is embedded in an entire paragraph dedicated to Mr. Brown's criminal history. Our position is that it was not erroneous for the district court to talk about the criminal history, but it was legal error for the district court to not mention stacking, not mention Mr. Brown's serious medical conditions, which are chronic bronchitis, obesity, and hypertension, and an ability to manage those in prison in light of the COVID-19 pandemic.
Well, he wasn't vaccinated. He refused to get vaccinated, correct?
Yes, that's
So how would he be able to manage it any better outside the prison system than inside if he was still not vaccinated?
But what Mr. Brown was saying in his letter motion is that he is not able to manage it because in the prison he is not able to effectively exercise. There were numerous lockdowns that were happening, and so he could not manage his obesity. And
No, his obesity.
yes.
Okay.
If there are no further questions from your honors, I yield the remainder of my time for rebuttal.
Thank you, Mr. Brown. Gracias.
Thank you, Judge Gregory. May it please the court. This court can affirm the district court's denial of compassionate release for 2 reasons. First, because the district court correctly concluded that the defendant hadn't established extraordinary and compelling reasons based on his health conditions and COVID, and alternatively, because the district court concluded that on the balance, the sentencing factor weighed against release.
But the district court didn't consider the 20-year disparity, did it?
I don't think the district court considered it explicitly in the sense of a claim-counterclaim type of analysis, but we know from this court's precedent, Kibble and High, for example. Well, first of all, just to step back for a second, this court in Bethia recently explained that the court can affirm even if there's a flaw in the eligibility analysis, so long as the 3553 factors are sound. And we know from High that the court can actually just skip straight to the 3553 factors. There's no argument here that the court wasn't aware, there's no evidence here that the court wasn't aware of the McCoy 924C argument because it cited it twice in its opinion, both at the beginning of the discussion section and then right before the 3553 factors. And we know the court also was aware of its authority to grant relief on that basis because it contrasted this case with its prior decision, that's the Gibson citation and saying, this case is not like that case because there, which is a case where Judge Dumar did grant relief based on stacked sentences, because there, the 3553 factors did support relief. And then the court went straight into the factors. And then at least 3 of those factors go straight to the heart, really, of any true McCoy claim, in fact, more so than the defendant really even made. The first is the defendant's criminal history.
Well, what if we disagree and don't think that the district court adequately addressed the extraordinary and compelling circumstance of this 20-year disparity? Opposing counsel says we should go ahead and order appellant's release versus giving the district court what would really be a third try in this case. What's your response to that?
I don't think this court should order the defendant's immediate release for a few reasons. Number one, that's an extraordinary remedy. I'm only familiar with one case, the recent Malone case where that happened, involving a 69-year-old defendant with debilitating, life-threatening illness. So I don't think that kind of remedy is warranted here. I wouldn't say it's the third chance for the district court to address the stacked sentence argument. It would be the third. It would be the third chance in this case. It would be maybe the second or the first time, at least post Ferguson, to address that issue. But I do think, and then there's also just a practical element to this, which is that even if I accepted the validity of the McCoy argument, even if I said it was extraordinary and compelling, and even if the district court agreed, the defendant has an independent...
You don't think a 20-year disparity in the sentence is just extraordinary and compelling, or at least something that should be considered as possibly extraordinary and compelling?
Well, first of all, I don't want to confuse what we're talking about, because initially we were talking about the 3553 factors. I was explaining why the court can affirm on that basis, even if the court didn't address the extraordinary and compelling prong of the analysis, so long as the 3553 analysis is sound. And I'd like to get to that in a second, but just to answer your first question, there's an independent 327-month sentence on count 1 here. That's totally unchallenged and barely even recognized in this case. So remanding for instructions to release the defendant, even if we all agreed that he should be sentenced per today's 10-year minimum, that doesn't translate to the defendant's immediate release because he still has a 327-month sentence for which he's only about 9 years in. So that kind of extraordinary relief isn't warranted here, both on the facts of the case, the procedural posture, but also the way the sentence is composed here. Again, I could stand here and say, we should give Mr. Brown the sentence he would receive today, and that would be 10 years, but that would still equal 447 years because of the 327-month sentence on count 1, which is consecutive to 9 and 11. But I do, going back to the initial question about the 3553 factors, I do think that the court addressed the core of the stacked sentencing claim in the course of its 3553 analysis. Number one, the district court addressed the defendant's criminal history, which was one of the core facts of McCoy. The defendant, McCoy, Mr. McCoy, he was 19 years old and he had no criminal history. The defendant here was 34 years old and came to the court, as Judge Dumar explained, as a Category 5. Totally different class of persons here. The defendant, and as Judge Dumar explained, his crimes had gotten progressively worse in the build-up to this case. That fact is reflected in the PSR and distinguishes this case from McCoy. Among the defendant's convictions are a conviction for firing a gun into a house during a robbery. This is not a first-time offender, and he's not a first-time firearm offender. The court also addressed, specifically focusing on the defendant's firearms, that in the court's view, the defendant was a risk to public safety because of his multiple firearm convictions. Again, takes us out of McCoy land. The district court in McCoy concluded that the defendant no longer needed the sentence and that he was no longer a threat to public safety. The district court here, on a different set of facts, concluded otherwise. And then, of course, we have the small percentage of the sentence served. Again, that's a fact that distinguishes this case from McCoy, and also because the defendant in McCoy, he was sentenced to 37 months on his Hobbs Act robberies, and then something like 384 months on his stacked sentences. And so when he came to the court, he was 17 years into his sentence, such that if he would get the relief that he sought, which he did, he would be free. But again, that's not this case, because we have a totally independent 327-month sentence on count 1, which wouldn't be affected even if we all got together right now and agreed that his stacked sentences were extraordinary and compelling. I'd like to just back up for a second, if the court has no questions on this issue, and talk about the health concerns. The defendant presented a number of health-related concerns which he asserted rose to the level of extraordinary and compelling when combined with COVID. The district court acknowledged all of those health conditions. Unlike the first iteration of this case, it didn't ignore any of them, and twice stated that the defendant's health concerns and COVID were extremely serious considerations, and that the court didn't take them lightly. And the court then addressed them in two groups, both times relying on CDC guidance. The first group the district court addressed pertained to the conditions such as sleep apnea and narcolepsy, which the court explained were not conditions that raised an inmate's risk of serious illness from COVID. And the court then moved on to the next set of conditions, specifically the defendant's obesity and hypertension, and in reliance on, again, CDC guidance, the court explained that those were conditions that could raise an inmate's risk of complications should they contract COVID. Per this court's remand instructions, the court addressed obesity, and per its own briefing order, the district court, which asked for the parties to address obesity, the court addressed that factor and concluded that obesity was significant, but for 4 reasons, the district court concluded that the defendant hadn't established extraordinary and compelling reasons based on his health conditions. The first was the vaccine denial. I want to just be very clear, the defendant tries to spin this as some kind of per se categorical bar about defendants who reject the vaccine. That's just not true. The district court looked at 4 factors. The first was the vaccine denial. The second was the fact that there were virtually no cases of COVID in the defendant's prison, 1 among staff members and no cases among inmates. The third was a high rate of vaccination among staff and inmates of the defendant's prison. And the fourth factor was that the defendant's conditions were manageable. The court's decision, in my view, is adequately supported by this court's precedent, specifically the court's recent decision in Hargrove, which explains that the inquiry into what is extraordinary and compelling is multifaceted and is nuanced, and the courts are supposed to look at an array of factors, not just the single question of whether a condition or a group of conditions raises an inmate's likelihood of serious illness. The court did that, and looking at the totality of the circumstances, the defendant's conditions, and the surrounding environment, concluded that he hadn't established extraordinary and compelling reasons. I'd be happy to answer any of the court's questions. I'm also happy to rest on our briefs.
Thank you. Thank you, Mr. Mateus. Mr. Brown?
Thank you, Your Honors. First, I'd like to talk about McCoy, because this case is actually...
You don't have much time, so did you get to respond to your colleague's question, response about the immediate release, giving the additional time he has? Would you address that? I think you need to respond to that.
Sure, Your Honor. It is our position that this is still a good case for immediate release. Counsel on the other side brings up Malone, and understandably there are differences between the medical conditions that defendant had and the medical conditions here, but yet Malone stands for the greater principle that district courts cannot ignore the most impactful claims that a defendant makes in a motion for compassionate release. Malone doesn't only talk about medical conditions, but it also talks about rehabilitation and how the district court in that case did not adequately consider.
But I think the government's point was that there's a separate independent count that where he's been sentenced to 327 months. How can we just release him when that's still hanging out there?
Sure, Your Honor. It is our position that because of the totality of the circumstances and his stacking, rehabilitation, and serious medical vulnerabilities, that this would be appropriate for that. But in any event, it would also be appropriate here for this court to remand for finding of extraordinary and compelling circumstances, and then for a full resentencing, considering Mr. Brown's rehabilitation, stacked sentences, and medical vulnerabilities. So that would be our alternative ask of the court. I'd also like to talk about McCoy. Opposing counsel says that this case is much different from McCoy, but McCoy does not set any hard lines as to what must be considered for there to be extraordinary and compelling reasons. It is this court's standard that as of now, with no policy statement, anything could be brought forth as an extraordinary and compelling reason. And so that court's consideration of the defendant's criminal history there and their age was not at all dispositive. Here, Mr. Brown shows rehabilitation and also has stacked 924C sentences, as did the defendants in McCoy. And so those similarities there make this case one in which the same finding should be had, that this is a case appropriate to find that Mr. Brown has shown extraordinary and compelling reasons. Also, in any event, time served.
What more would you want the district court to do other than what they've set, what the court set out in its 3553 analysis?
Well, first, Your Honor, they needed to address stacking. They needed to address the disparity that is caused by Mr. Brown's stacked sentences. Second, they needed to address Mr. Brown's serious medical vulnerabilities in light of COVID-19. And third, the district court needed to adequately address the mountain of post-rehabilitative evidence that Mr. Brown put forth, not just minimizing that to one cursory sentence about appreciating service. Also, when it comes to time served is not dispositive in any event. As I mentioned, there was a miscomputation, and it actually should have been over a quarter of Mr. Brown, about a quarter of his time served if stacking would have been considered. But this court has found in Martin that compassionate release could be granted for a defendant that only served 9 years of a life sentence. So even taking the stacking argument out of that and keeping it at 11%, the time served proposition that the district court put forth should not change this court's decision today. If there are no further questions, we ask that this court remand with instructions to grant immediate release, or in the alternative, and at the minimum, remand with instructions for full resentencing in accordance with Mr. Brown's rehabilitation, stacking, and medical vulnerabilities. Thank you.
Thank you, Mr. Brown. Professor Yang and Mr. Brown, thank you for your able presentation. Fox.
May it please the court, my name is Will Fox with the law firm Winston & Strawn. I represent the appellant petitioner Minna Marie Brandt. This is a wrongful retention case under the Hague Convention in which the district court committed what is clearly a legal error that this court should review under the de novo standard. The district court erred by determining whether the appellee violated Ms. Brandt's custody rights to her children by determining Ms. Brandt's custody rights with reference to a March 2022 Swedish court order that postdated the wrongful retention of her child by around 8 months. What the district court should have done under this court's precedent in White v. White and the clear text of the Hague Convention is evaluate Ms. Brandt's rights as they existed at the time of the wrongful retention in July, specifically July 7th, of 2021.
So counsel, can I ask one thing right off the bat? Article 17 of the convention is what I'd like you to help me with. It certainly says that that a custody decision shall not be the sole fact, but it says that it may be taken into account. Now, it's not talking about the date or chronological. There's nothing specific about when that custody decision is, and I'm familiar with the White case. So does White preclude us from even looking at the March custody order, or is there a way we're supposed to look at it, and if so, how?
Yes, Judge Quattlebaum. I will specifically address Section 17 first, and then I'll move on to your question about White and whether it prohibits any reference at all to that post-wrongful retention order. So our position with respect to Section 17 of the Convention is that it doesn't apply in this case at all, really. It gives an example of one thing that is not sufficient on its own for a court to refuse to send a child back to a home country. The Meredith case that the appellee relies on in their response actually illustrates the point of Section 17. So in that case, what happened was a man who was a respondent in that case had custody under United States law of the child that was at issue. Before that happened, the mother had taken the child overseas. But once custody was granted to the gentleman, he regained custody in Arizona of the child. What happened next is when Section 17 comes into play. The mother was in England, and she obtained an order from a court in Birmingham and tried to use that order as the basis of a Hague Convention petition in Arizona District Court. And the District Court relied on Section 17 to say that order that you've obtained in England cannot be a sole basis for us to send a child the child back to you. To get to the rest of your question about the extent, if any, to which the court can consider the March 2022 order, the courts need not totally ignore it. Indeed, both we have relied on part of the 2020 order in this case to illustrate the content of the party's rights at the time of wrongful retention, which is proper for the court to do. And as the appellees point out, the court did that in White versus White. What happened in White versus White is that in Switzerland, a man and a woman had a child. The woman, under Swiss law, had sole custody of the child. She took the child out of Switzerland to the United States. There was subsequently a Swiss appellate court decision, and that appellate court decision is what appellees point to as an analog to their reliance on the 2022 order in this case. But what this court recognized about that post-wrongful removal Swiss appellate decision was that it was authority of what the mother's rights included under Swiss law at the time of wrongful retention. If you continue on through White, another subsequent Swiss order purported to give the petitioner in that case joint custody of the child again. And that is the order that this court said should not be considered in that case, because what that order did and what the March 22 order did in this case purport to, and do indeed under the home country's law, change the party's rights with respect to the children. The March 2022 order does not say under the previous...
The March 2022 order, correct, gives custody to appellee, is that right?
Yes, Judge.
So the Swedish order and the United States order both give custody to the appellee, correct?
I'm not aware of a United States order in this case.
Okay, I'm sorry, the district court's conclusions.
Yes. So what the district court,
I'm, in the culmination of the Swiss order, the March 2022, which gave custody to the father, was that the culmination of the investigation that started in December 2020 when there was an investigation started as to whether the mother's home was a safe environment?
I think it may be fair to characterize it as the
Okay,
culmination.
then
of
it's
that.
all right. And the beginning, that investigation in December 2020, wasn't that part of the reason the appellant and appellee agreed that appellee would take the children to America?
So the investigation, I believe,
Child Protective Services was about to take the children from the mother in Switzerland, which the Swiss order ultimately did in March of 2022, correct?
so yes, but to clarify, Switzerland was involved in White versus White. Here
Right,
we
I'm
have
sorry.
Sweden.
Okay, Sweden,
Yeah,
thank you.
Yes, yes, Judge. So what I will say about this agreement that the appellees have relied on, it is a red herring in this case. Under Swedish law, as we have discussed in our briefing, on July 6, 2021, the Swedish courts ruled that the parties had joint custody over the children. Wrongful retention.
How is it wrongful retention if they had joint custody?
Because
Why are her rights more, why are her rights superior to his rights at that point when they have joint custody and when they did both agree that the children would come to the United States?
So I have two responses. The first response is that Swedish law, the Parent and Child Code, provides for procedures that must be obeyed when a person with joint custody of a child wants to change the child's residence. One of two things has to happen. There has to be a Swedish court order approving the change of the child's residence, or there has to be a written and signed agreement by the parties that is also approved by Swedish social services. Neither of those things exist in this case.
So practically speaking, now that in Sweden, there's been an order entered removing custody from appellant, where, if we rule in your favor, where would the children go?
The answer is that they would go back to Sweden.
To where, foster care? Or whatever the equivalent is there?
First of all, I believe that is outside the purview of what this court should consider.
Well, I'm asking you, so where would they go, practically speaking?
The record evidence in this case is that Mr. Caracciolo would go wherever in the world with the children. I think his testimony at trial is that he would follow them to the ends of the earth. So if the court ordered the children back to Sweden.
So the father would go back to Sweden with the children,
That's what
But does the treaty require that? I mean, that if we accept your argument and order the child returned, let's say the plane lands in Sweden.
Sorry, the what?
The plane carrying them lands, and they get out, and they're on Swedish soil, and then they get back in another plane and come to the U.S. That wouldn't be improper, right? Because now there's an order that your client doesn't have custody. So this just seems so weird. I mean, you have a technical reading of the statute. It may be right, but it seems to me if they went back and then just got on another plane, there wouldn't be anything wrongful with that removal. So I mean, it seems like we're just kind of going through this kind of technical issue where kids' lives are at stake, and maybe we're bound by the treaty and we do that, but I don't understand why I say it couldn't happen would be improper under the Hague Convention. Do you think it would be?
So to be quite straight with you, Judge Quattleman, I don't think that it would be improper if the world is exactly how I understand it to be right now, which is that there are no Swedish proceedings ongoing with respect to the children. I do not know what would happen. For example, if tomorrow Ms. Brandt initiated a proceeding, there's not evidence in the record about that. The evidence in the record is that she would do so if the children went back. I don't know if that would prevent him from taking the children back. But if there's nothing under Swedish law preventing him from doing so, I think that's something that could happen. To focus in on another thing that you said, Judge Quattleman, I think that the treaty does still require this result because of its remedy and because the plain language of the treaty is that you consider the party's rights at the time of the wrongful removal or the time of the wrongful retention. And there's good reason for that. And the facts of this case actually illustrate why there's good reason for that. If you look at the March 2022 custody order, there are various reasons in there related to the best interests of the child, why the Swedish court decided to award sole custody to the appellee. Some of those reasons are that the children were already in the United States, and because considering of the best interest of the children, the fact that they were in the United States, according to the Swedish court, made awarding joint custody difficult, according to that order. So what the presence of the children in the United States did is influence how that March 2022 order came out. And the upshot of that, when the court's thinking about this class of cases as a whole, is that before proceedings in a home country have concluded, a person with joint custody could take children over to the United States in hopes that the courts in the home country would consider that as a reason to award that person sole custody, which appears to, I'm not saying that that's why the children were taken to the United States in this case, but that would be a result that would be arguably
Why were the
incentivized.
children taken to the United States in this case, in our case?
So I believe that the children were taken to the United States because the parties agreed that they can go there. A dispute below, which I think ought to have been resolved in favor of my client and appears not to have been resolved at all, was that it was agreed that the children would come to the United States for a limited period of time. The evidence in the record, I believe, is for a 3-month period of time.
Well, the evidence in the record is contrary because appellant at one point says 3 months, but then later, and I think the district court cites this in its order, says that she was not sure how long it would be.
Well, so the district court did say that in its order, and I believe, oddly, the district court's finding on that issue is that the evidence is conflicting, which seems really like a non-finding to me.
Why is that a non-finding? I mean, one of the defenses or exceptions to a wrongful removal or wrongful retention case is that there was an agreement. Now, I know it's got stuff about being sanctioned by the Swedish law, but anyway, I mean, what looks like what the district court said is I can't tell that there was an agreement.
So that exception is akin to an affirmative defense that a respondent can raise in a Hague Convention case.
Right.
The district court does not purport to resolve any affirmative defenses in its order. I can see how that would be relative to that affirmative defense, but the burden would actually be on the respondent to prove that affirmative defense.
Maybe, but to your point, if the district court didn't resolve affirmative defenses, shouldn't we send it back to say, hey, there's some affirmative defenses and there's some exceptions under the convention that haven't been addressed? Even if we agree with you on the removal issue under the treaty, aren't those still live issues or issues that haven't been resolved?
So Judge Quattleman, I'm quite out of time. I can respond to your question if you would like.
You may.
Okay. So Our position is that the court need not remand for consideration of those affirmative defenses. The two affirmative defenses that were raised in the post-trial briefing below were essentially a statute of limitations defense. And this, I believe it's called the acquiescence defense, which is that the respondent must show that petitioner acquiesced to the children's presence in the United States. As to the first one, I think we explained pretty clearly in our brief why there's not a statute of limitations problems here. And I'll move to the acquiescence one here just very quickly. And the evidence in the record, which is pretty clear in our view, that there was no consent to an indefinite trip to the United States, are in both the September 2021 Swedish Social Services report and also in the March 2022 order, on both of which appellees have relied. And I can give you, in the September report.
You don't need to cite that. I'm familiar with that language.
Okay. And the same for the March 2022 report? Okay. Well, with that, Judge, I have no time to yield, so I will be finished.
Thank you, Mr. Fox. Mr. Epperson?
Yes, Your Honor. Excuse me. My name is Steve Ackerman. I filed a notice of appearance, Your Honor, in this case. It's amended notice. And I'm with co-counsel Lauren Watkins. We're here on behalf of Mr. It's actually pronounced Carcello. I know it's a hard one. I want to jump right to the point that Mr. Fox made about what happens. It's Judge Thacker's question. What happens if the district court sends this child back to Sweden? And the problem is that she lost the appeal in the custody case that she filed prior to the alleged retention date. She lost that appeal. She does not have custody at all. The child goes back, foster care swoops in, takes that child, and that's the end of that. The child is then in state custody. Nobody has custody. Our client, per the Swedish law, the court order, does have custody. And so he could then, therefore, get back on the plane, very next plane, fly back, and he is entitled to do that by the court's order. I would like to jump right into the White case, because that's obviously this court's case from 10 years ago. The appellant has sort of pinned her entire appeal on the assertion that a post-removal order should not be considered at all on the issue of wrongful retention of a child in the U.S. But that is not what White held. And White did not repudiate Article 17. White merely stands for the proposition that wrongfulness depends on the type of custody at the time of removal. But it does not hold that you can never examine a subsequent order to get to that issue. And I note that in White, there was actually 3 court orders. The first one was a pre-removal order that gave this nebulous right to the mother of custody. It didn't explain what that meant, much like our case. There was a post-removal order a year later, 2010 to 2011. The post-removal order clarified that that mother had sole custody. And then there was the later order, which White talks about. You can't, or you shouldn't really consider that order. It was 2 years later that said, we're switching custody to father. 2 years later. But the White court, at the very end of their opinion, they made it very clear that that order did not repudiate the original 2010 order. It did not retroactively change that order. So the White court said, this new order doesn't tell us much because so much time has gone on. But we know now what the 2010 order said. And that's all that White says. It doesn't say you can't look, black and white at another order. I think that's just...
Counsel,
Yes, sir.
Let's assume we believe, just for not right now, I'm not deciding this, that White, directs us to look at the time of the removal.
Yes,
or the time of the retention, I should say retention. At that time, it seems pretty clear that under Swedish law, there's joint custody.
Yes, sir.
And, Swedish law says things about what happens with joint custody. I mean, Section 14A talks about changes of residency. Section 13 talks about other things and references Section 11. It seems that at least strictly under Sweden's law, that, the mother has equal rights in those sort of decisions. And so she would have say-so in, the decision for the children to stay in the United States or not under the applicable law. Do you disagree with that? At least if we are forced to look at this by our precedent at the time of the alleged wrongful retention.
Yes, I do disagree with you, Your Honor. I would turn it a little bit by looking at what joint custody means under Swedish law, and we don't know. We don't know under the convention what joint custody means. It's just not defined. And in fact, in the explanatory report to the convention, to the Hague Convention, cited in appellant's brief, it says in section 11, the type of legal title which underlies the exercise of custody rights over the child matters little. It's just a phrase. Where I practice, we don't know what joint custody means. It's something that everybody tosses out. We know what sole custody means. And in this case, there was testimony about joint custody. There was an interim order granting joint custody, but it did not require a return. There was the Social Welfare Committee's report, which recommended sole custody to father, and that mother could not have custody because of her issues. And the import of that is that the appellant...
Why didn't Swedish law tell us? You say the Hague doesn't talk about what joint custody is. That may be true, but Swedish law may not say everything about joint custody, but it says some things about it. And what it says about it, it seems like at least includes the right to say where the children are going to live.
I could not find that anywhere, Your Honor.
What about 14A? If both parents have custody of the child, the court may, on application of one of both, decide which parents is to live with. The parents may enter into an agreement concerning where the child lives. This agreement shall be valid if it's in writing and the Social Welfare Committee approves it. Isn't that pretty much saying both parents have a right in that decision unless there's an agreement approved or a court order?
Well, here's where we get into the problem of proof, Your Honor, and why she couldn't prove her case. There was evidence of a written agreement, at least it was talked about, but it's never been produced. We haven't seen it. And you have conflicting facts about whether they actually had an agreement, and a big conflicting fact where the appellant herself testified, I don't really know that we set a retention date. I don't know what that was. We didn't have one.
So I hear you, I think there. I think the district court said that there was conflicting evidence of an agreement. And absent an agreement, don't we default back to the law, which says that both parents have the right to be part of that decision?
Well, if it said that somewhere, Your Honor, I would agree with that. But what you have is the district court looking back at an order that talks about a Social Services Committee report as well as an investigation, which made very clear father should have sole custody. They knew that this child was in the United States when they started that investigation. And so I think we have to look at, and I think also, Your Honor, we have to look at the Social Services Committee as a source of law.
And you're talking about the March 2022 order? Is that the order you're talking about? What's your best argument as to why the district court could consider that order, which was nearly a year after the alleged wrongful retention occurred?
Yes, ma'am. I think the opponent's argument is that the court, its entire decision was based just on that order. And I think the court made it very clear that was not the case. It looked at it as evidence. And I don't think the court had to tell us what evidence meant in that case. It's just something the court looked at.
Okay, so I guess my question again is, why was the court entitled to look at that? Or do you agree that the court should not have looked at that?
No, I think absolutely it should.
Okay, so why could it, what's your best argument as to why that was appropriate to look at that?
As I distinguished White, I don't think White says that you can't do that. I think actually the court in White actually did look at the order. Otherwise, they could not have determined sole custody. They looked at the previous order and found that it was custody. They looked at the subsequent order and saw the word sole custody, and they used the word sole custody at the very end of their opinion. So they were looking back. The other case, there's an Arizona case, Meredith. That's exactly what they did. They went back and looked at an order to determine what the rights of custody were at the time, in that case of removal, I believe. I don't think Article 17, there's no prohibition against Article 17 for obvious reasons, but Article 17 allows us to look back. I mean, I think that's unequivocal, that you can look back and take into account the reasons for a decision. And, if we want to take discretion away from the court, the convention certainly had a way to do that. The signatories could have put that language in there. You're not allowed to look at anything that happened after. And it did not
What
do
if the
that.
March 31st, 2022 order was removed from the equation? Could the district courts still be sustained?
Yes, ma'am, because she didn't prove her case. The appellant could not prove her case. She could not prove there was a return date. There's conflicting
If we
evidence.
found that considering the March 2022 order was not appropriate, though, would we need to remand it back to the district court to consider it without that order?
I would say no, Your Honor, because that's not what the order depends on. You remove that and you have the same fact that Ms. Brandt could not prove beyond a reason, or by preponderance of the evidence, that her custody rights were breached. And that's all she had to do. The other two prongs weren't even contested.
But it sounds like the way you're saying that she didn't prove the custody rights were breached is because there is uncertainty on whether there was an agreement to return them. Is that right?
I think that's part of it, Your Honor.
Okay. What else is it?
And I think also, well, the court did look at the Social Services Committee's report.
Which came after the wrongful retention, right?
One moment, Your Honor.
I think that was September after the July.
Yes, that came after.
So
Yes,
the
sir.
two things the court looked at is a report that came after and an order that came further after.
Well, and also this meeting that they had at Social Services even prior to removal, where they were told that the children would go into foster care rather than mother's custody.
Right.
So the court considered the initiation of the investigation in Sweden that began in December of 2020?
Yes, ma'am. Yes, ma'am, they sure did. Let's see, there's one more thing. There was an interim order, Your Honor. And that didn't help a whole lot because it just talked again about that Ms. Brandt did not have sole custody, and then it used this phrase joint custody again. But what's interesting about that interim order, the court clearly knew at that point that the children were in the United States. There is nothing in there that says, you got to bring those kids back. They just let it be. And I think that our court could certainly look at that and say, I'm not seeing where this was a wrongful retention. That he was allowed to take those children. Our court did not say, or the Swedish court did not say, bring them back now. And I think they certainly would have. I don't know why they wouldn't say that. One moment, Your Honor. I did want to address. Again, I don't think we can look at any of these cases without looking at Article 17. We can't just gloss over it. The White Court, interestingly enough, did not address Article 17. It just was not mentioned in there, and I looked and looked. But Article 17, we can take into account a decision related to custody, and it doesn't have to be a court order. It can be other things. And it also, Article 17 tells us nothing about pre-retention time periods, post-retention time periods, or pre- or post-removal periods. The court can look at any of those. And from the explanatory report again, it references administrative authorities must be understood as a simple reflection of the fact that in certain member states, the task in question is entrusted to such authorities. So if the Social Services Committee is saying, Mom, you cannot have custody, she's not going to get custody, and that is a source of law that should be considered by our court. Also, in Section 69 of that report, the word decision is used in its widest sense and embraces any decision or part of a decision, and I would argue that means judicial or administrative. So social services can come in, take your children, they can remove your parental rights. There's all kinds of things they can do, and that is sanctioned by the force of law. And I think that's what's going on here. Our court is looking at that and saying, you don't have custody. There's nothing in here that says you can't take the children or that you have to bring them back. And you have a burden to prove by preponderance of the evidence that your rights were breached. And she could not do that. And so we're just asking the court to affirm the lower court's decision. And that concludes my presentation. If there are any questions, Your Honor?
Thank you.
Thank you.
Mr. Fox.
Several points. I believe I'll need to use all of my 5 minutes on this. The September Social Services report, which is also post-wrongful retention, and which has been characterized as having the force of law, did not have the force of law. Section 5 of the Swedish Parents and Family Code says who gets to determine custody of the children. The courts get to determine custody of the children. That report even recognizes that its recommendation would have to be accepted by a court. The March 2020 second order later did that.
Mr.
With
Fox,
respect,
Mr. Fox, isn't your problem that you can't establish there was a wrongful detention? Because the Hague Convention, which is the gateway to jurisdiction here, United States, requires wrongful. And isn't it understood that under Swedish law, they had joint custody? I mean, forget about the orders. They had joint custody at the time, correct?
yes, they had joint custody, and
Okay.
that's the reason that the wrongful retention.
Wait a minute, if they had joint custody and the children come to the United States with him, how is that wrongful?
Because under Section 14 in the Swedish Parents and Family Code, the only way that anyone with joint custody could change the residence of the child was to get a court order or to get a written agreement with the other parent that was approved by social services. And
That's
neither
a residency
happened.
question. That's not necessarily custody, joint custody.
Well, it's a right of a person with joint custody to have those procedures followed. They get to have a certain amount of say in
Well, she
where the
also
child
would
gets to
also
live.
have a right to try to establish residency in the United States. And while here, but in Sweden, could he not petition for that? They both would have a right to try to change residency, but that's not the question. The question is wrongful retention at the time that he had joint custody. What makes that wrongful?
Because he is purporting to change the residence of the child in violation of the rights that Ms. Brandt has under Swedish law. That the
How
residence.
did he petition for residency?
No, he didn't do either of those.
Well, then how was it wrongful then to have his children with him in the United States?
What was wrongful about it is that he brought them here and then kept them here indefinitely. His own position is that he was changing the residence of the children.
Indefinitely? Well, let's
Yes.
look what indefinitely, children are dynamic. They're not some, like this, stick them here, they're dynamic. What was going on in Sweden? Not very well for the mother. So what is he supposed to do? Well, I guess I'll send them back. Into what? Into what?
Are
A
you,
foster, I'm talking about the facts of this case, a foster placement? It's not disparaging anything. Everybody wants the best for mom and dad and everybody and the children. But the point is, you have joint custody of your children with you safely. You're saying that's wrongful because you extend a stint in the United States with your children, which you have joint custody with, given the circumstances? I don't think you've established that it was wrongful. That's the key. Forget about the orders afterward. All the orders afterwards just hurt your client, your case completely. But if you took all of that out, where is the wrongful?
so my position is that it is wrongful because Mr. Crociolo violated Ms. Brandt's rights by purporting to keep the children here indefinitely.
Her rights?
Yes, her rights. Her rights are that as a joint custodian, I've said that 2 times, of the children, is that the children cannot be taken and have their residence changed without a court order or her written agreement approved by social services.
They weren't taken. They were with the approval of her.
The indefinite retention of them here was not with her approval. I don't think there's.
So when did it become wrongful?
It became wrongful
What-
in July, on July 7th, 2021. That's when the
The
record.
exact date that for 3 months? The 3 months
So there's-
expired? I'm just asking you, are you saying this because that's when the 3 months ended? And that was wrongful
Yes.
by any court order, do you know?
No, it's not wrongful.
And by any agreement that was written at all?
So
Is that all those are no's, I take it, because you're moving on? Is that no? There was no law violation? except for you said that to change residency, you have to petition.
Yes, we're not complaining that a Hague Convention remedy lies here because of a trip with temporal limits to the United States, but that's not what happened here. The appellee's position in the case is that there was an agreement that he could take the children to the United States indefinitely, forever. That is the story that they told in the district court. That's the story that they told in their briefing. That is what Swedish law did not allow him to do. And I'm out of time.
The courts knew where they were when they adjudicated the case against her. They didn't say anything but you're talking about. They had opportunity to say exactly what you said.
Well, so
And they did not.
In the September 2021 order, the September 2021 report actually acknowledges an agreement for a trip of 3 months, and so does the March 2022 order. So it makes sense that the Swedish court on July 6, 2021 would not order the children back at some point, because those subsequent Swedish legal documents show that the Swedish authorities did believe there was an agreement with respect to a limited trip.
And enforcement of that retention would be that the children would go to foster care, right? Because your client couldn't. It's already been determined that she wasn't able to do so. So you're saying that it was wrongful because children should have been in foster care in Sweden. Is that right?
At that time, it's not clear from the record that the children certainly, beyond any doubt, would have gone into foster care if they had come back from the United States at that point. And I
I
disagree.
thought the record was, unfortunately, given the mother's circumstances, either the child go with the father or they would go to foster care. Is that not right? Is that not right? You're just hunching your shoulders. I'm asking you a question. Is that not right? You can tell
I'm
that.
second guessing myself now.
You second. Okay, that's all I have. You represent as officer of court. That's all your response is. Go ahead. You have some time left, I guess. No, your time is up, but I took a couple of minutes, so you can have a couple of minutes more.
Oh, no. My last thing that I said to you was that I was second guessing myself about whether she had to.
Go ahead.
Children would
Finish your
certainly
time.
go into foster care. So I just want to make clear that that's what I said.
I want to make sure I heard that too. So did you just say you agree with Chief Judge Gregory that if they came back to Sweden, they would go into foster care?
No. So if the question is back then, I said that I can't remember at this very minute.
So
I disagree that if they went back now, that they would absolutely have to go to foster care for the reasons that I discussed earlier, which is that the father has said that he would go with them. And if the father went with them, presumably they would be with him because he has sole custody over them and would not need to go to foster care. Indeed, as I also agreed with you, Judge Quattlebaum, earlier, he could also bring them back. I do not agree with the premise that this court's decision to return the children to Sweden would be forcing them into foster care. With that, I will conclude my remarks.
Okay. Thank you, counsel, both for your arguments here. I'll ask the clerk to adjourn the court.